हेलो।
और मेरी तो सुन
हेलो। अभी लेट बैठेंगे सर, इसका रो ठाकुरी चला चढ़ा आया है कि नहीं हो गया हम लोग को निकला आए तो हो गया अकेले आया जल्द से आया उधर लगा गिरा लगा मेरे आपका
ठीक है, थैंक यू। मुंशी जी ऑफिस नोटिस मांगिए 6 नंबर फाइल जरा सा दीजिएगा भाई। आइटम नंबर 6 LPA है। आइटम नंबर 6 अच्छा LPA है हमारा सुरेश सिंह। आइटम नंबर 6 ऑफिस नोट देखना होगा ना।
मेरिट पर सुनेंगे, मेरिट पर सुनेंगे, इग्नोर कर देते हैं।
मेरिट पर सुनेंगे तब आज टाइम नहीं लगे। May I with regard to item number 6 on office notes, my lord.
जी।
I remain under the confusion that there is some office note. That's why, my lord, I am not prepared. Prayer is not today and not tomorrow.
आप अगर आइटम
हम
नंबर
तो
6 तक आप वेट करें, मैं समय दे दूंगा आपको।
not today and not tomorrow, my lord.
आप उस समय तक वेट कर सकते हैं जब कॉल होगा, देख लेंगे। अगर ऑफिस नोट्स को रेक्टिफाई करना होगा, उसको करना होगा, उसके लिए समय दे देंगे, या फिर मेरिट पर आपको समय दे देंगे कि आप मेरिट पर बहस करिए, इग्नोर कर
क्या
देंगे।
कहते हैं तो सुनते हैं।
कॉल होने दीजिए,
हाँ?
कॉल।
हाँ?
आप बैठ जाए मिस्टर नारायण सिंह, अब आप अपनी जगह ले लें कहीं। चलिए। यस,
permitted to mention a case, my lord. Two cases, my lord. They are related to PDF matter, my lord.
what is the urgency? All matters are being listed.
Mike, will listen. Mike. Oh, for listing.
All matters are being listed in it on its priority. I mean, what is the problem? Why are you mentioning? We are almost completing 2021 matters. 2022 matters are being listed.
मेरा ये हुजूर 2018 और 2019 का है।
18-19 क्यों नहीं लगा है? देख लीजिए।
इसमें हुजूर इसी एक्ट का ही मैटर है। हुजूर अर्ली ऑनरेबल जस्टिस हेमंत कुमार श्रीवास्तव के यहाँ चढ़ा था।
आगे बोलिए क्या है?
और उसके बाद इसी एक्ट का हुजूर 2020 चल रहा है।
May I mention, my lord?
Yes.
CL number 15, my lord. Admission, my lord. I pray for 1 weekend, my lord.
Let the case be called out. We'll see what is the matter.
लॉर्डशिप में परमिटेड टू मेंशन 2019 का हुजूर केस है, पीडीएस डीलर का।
इसी
नबी
एक्ट केस?
जी इसी एक्ट
क्यों
हुजूर
नहीं लगता है? अब तो हम 2020-21 कर रहे हैं, 22 कर रहे हैं। Yes,
From list, my lord.
बोलिए।
Serial 18, my lord. Pray for 2 weeks time, my lord. Because
Let it be called out. We are granting adjournment, but only when the case is called out.
all right.
For order on office notes, serial 2, Mr. Mukul Sinha.
Yes, Mr. Mukul Sinha, you were not there. I got a message sent to you.
Well, there was a confusion yesterday. I ran to the court number 15 and then I was told for 12 and ultimately 6 was the right.
Now you have a choice, Mr. Sinha. We will await the outcome of that arbitration proceeding before Honorable Justice Gopal.
Mine.
Is that okay? Yes, Mr. Srivastava.
My lord, yes. Or it could be, my lord, disposed of and they can proceed afresh after the amount
That may
is...
not be correct.
Let
Because
the
we'll be
matter be
deciding the
pending.
For the purposes of determine, my lord, then I just am making that submission, my lord, for the reason that so long as the amount is not determined, my lord, determination and ascertainment of the amount
What has
which...
happened in the second proceeding, second certificate case?
That has been
What has happened in the second certificate case?
That
which
is
was-
still pending, my lord. No further action
No
perhaps.
further
No,
action
no.
is being taken. Now, if they proceed against you in that matter,
My lord, that is there. However, my lord, considering that the amount has yet not been
they have
ascertained.
followed your argument. It is precisely for this reason that we are awaiting
My lord.
the outcome of the arbitration proceedings. What is the arbitration proceeding before Gopal Prasad, Honorable Justice Gopal Prasad for? It's only for ascertaining the
My lord, yes.
exact amount.
And additionally, my lord,
With all
also...
Additionally,
my lord, there
With
are
all
other...
ye respects, so far as amount is concerned, that has
All right, we
already
will
been-
await now. Let us hear you later. Yes.
And one more small point, my lord, if I may be permitted to submit before my lord says.
Yes.
That we had raised all these issues in the writ application, my lord. It was not just reliance upon Kanhaiya Lal's case, my lord, that we had
No,
filed that.
that,
However, the learned honorable single judge, my lord, having taken note of that one technical issue which was there, my lord, had decided the matter, and that liberty was always available to them, my lord, to proceed afresh in accordance with law.
At the same time, no verdict on merit of the case has been taken up. That's the order under appeal.
And what is the outcome of the miscellaneous case number 10 of 2016?
That is
they
also
have-
pending, my lord. That is still
That
pending.
they have filed.
what is, where are the details of that arbitration proceeding before Honorable Justice Gopal Prasad?
My lord, that is,
Your supplement, your counter affidavit filed on 6
that is, my lord, reply to the memo of appeal that we have filed, my lord. 4/3/2020, my lord, we had filed this.
No, the counter affidavit which you filed on 6/5/2022, the last one.
Last one also had it, my lord, the earlier affidavits also.
Show us from that.
My lord, the
That
last
affidavit
one.
is before me.
The last affidavit that has been
Yes.
filed. My lord.
Therefore, I am giving you the
Annexure-
date,
annexure-
6/5/2022.
My lord, yes. Annexure R/7, page 20.
Give us this statement, which paragraph? I had read it somewhere yesterday.
My lord, para 17 at internal page 7 of the affidavit, my lord.
Para 17.
My lord. It is relevant to state here that all of a sudden by letter dated 10/3/17, the agreement dated 14/3/11 was terminated by the corporation, and the respondent company filed a request case bearing number 20 of 18, and an arbitrator was appointed by an order of this honorable court. And
No, but you were interested in termination. You are not interested in continuing. मेरी आवाज नहीं पहुंच रही है.
आ रही है.
You are not interested in continuing with that agreement because they had not formed,
My
they
lord,
had not
yes.
completed their part of
Their
the
obligation, my lord, they had
given-
not
That's
fulfilled.
right.
My lord.
So therefore, you would not have challenged the termination per se, but you would have talked about your responsibility of payment.
My lord, yes.
So therefore, we will. It would be prudent for us to await the outcome of that.
Oblige, my lord, yes.
That's what.
But these are the basic issues and the disputes which are involved in the present matter, my lord.
right. You have
We
said
were
that.
relying upon all these things for the reason, my lord, that so long as this is pending and ascertainment has not been done.
No, if we decide this appeal,
My lord.
perhaps all these proceedings would become infructuous. Now, if we say that no, the single judge was wrong in relying solely on Kanhaiya Lal,
My lord.
the proceedings could simultaneously be done against you and the managing director. Now, if we say that, or we take the view that the London single judge was right, in either case, the proceedings.
But my lord, while the order was passed in the order which is in appeal before my lord, the liberty was always available to the corporation to have moved the case against the corporation rather than the managing director of the corporation. That order, they had never been stopped, my lord, or there was not some kind of a permanent
that's
injunction
something-
against them.
That's that proposition of law that you are saying, that what you are expecting of the corporation, if the order of the single judge is sustained,
My
now
lord.
we have reservations in sustaining that order.
However, my lord, it was only on that technical
Therefore,
point.
I say that you await the result. That would be a wholesome thing. I mean, what is decided? What was your responsibility? If that is decided, perhaps the amount which you are required to pay, if at all you are required to pay, that would be ascertainable.
My lord, what I am submitting is, even in an event where, my lord, if at all, although assuming against my own interest, my lord, if the learned arbitrator, he passes a verdict against me, and there is an X amount which is determined to be payable by the corporation in favor of
You
my lord.
still have an option of challenging.
In that event, my lord, no, we are not on that, my lord. In that event also, my lord, when the matter is taken up before this honorable court, the present case, the issue with respect to the certificate case having been filed against the managing director in his personal capacity, rather than the corporation, would still be, my lord, pertinent to be decided by this honorable
Let
court.
us see whether the corporation becomes wiser after the proceedings.
We have our most sincere doubts about that, my lord. The corporation has a long checkered history, sir.
With all respects, my lords, there is already a earlier arbitration.
Mr. Mukul Sinha, your corporation would have been well advised in filing a fresh petition incorporating the new demand that you have raised against them.
New demand is for in the another certificate case,
that's all
16, 17. We'll file it, but so far as this case is concerned,
I think you have not understood the observation of the bench. The earlier certificate case was for a particular period. Now, you started another certificate proceeding giving an impression to this bench that the earlier proceeding you have dropped because of the decision by the single judge. But when the court confronted,
we have not
just a
dropped.
minute, when the court won't, you don't have to respond in the interregnum. The court is only trying to make you understand.
I'm sorry.
Now, when you filed your supplementary affidavit and you explained to the court that that was for a different check period, it was not even on the basis of the amount which was claimed by you against Mr. Srivastav in the first proceeding. It was a fresh claim post the first proceeding, Perhaps, therefore, I say that you would have been well advised to do it in accordance with law in a composite manner afresh, since that proceeding was dropped. You chose to file a certificate case, initiate a certificate case with respect to a limited amount, which accrued after the period for which the earlier proceeding was detracked. Have you followed what I have said?
I have followed.
So therefore, now you would become wiser after the arbitration proceedings are over and the award is passed. And what is the result of the miscellaneous case? Now that would give you a fresh lease of life. Otherwise, you stand on a weaker footing. Not that we are trying to help you or help him, but then if something is due to you, it must be paid to you. They can't have an unjust enrichment in their bank account.
That is what my case is. For
Take
6
down.
years, they have been
Awaiting the outcome of miscellaneous case number 10 of
arbitration.
2016 and the arbitration proceeding before Honorable Justice Gopal Prasad. This case is adjourned to. We give 2 months time.
2 more times. But why, my lords, my lords had observed to wait till the arbitration case pending before Honorable Justice Gopal Prasad. But civil miscellaneous, so far as civil miscellaneous is
Both the cases.
no, civil miscellaneous is against an order which has already been concluded by an arbitration award.
And what happened ultimately? Chhod dijiye miscellaneous. He's right. He's right. Forget about miscellaneous case. You're right, Mr. Singh. That would unnecessarily linger the matter. Awaiting the outcome of the proceeding before Honorable Justice Gopal Prasad, this case is adjourned to 2 mahine ka date lagai.
5th of September.
Interim order in any.
My lord has indicated the case number also, the case which is pending before the
Yes,
learned
what is that?
arbitrator.
What is that?
It is 1 of 19 and 2 of 19. my
One
lord.
of 2019.
19, my lord.
1 of 2019 bracket.
And
All
in,
right.
in the other case, 2 of
2 of 19. There are 2 LPAs, my lord. So 1 of
Ek
19.
mein order karna 1 of 19, the other 2 of 19.
2 of 19. We have given the details, my lord, in the supplementary affidavit. that is-
Give the date.
5th of September.
All right.
Obliged, my lord.
Serial 3, Mr. M.S. Vinita Singh.
Look here. The respondent numbers 1 and 5 have been served. The notice addressed to respondent number 5 has been accepted by respondent number 1, which is accepted to be a valid notice. The respondents number 2, 3, 4 and 6 have not been served. You are appearing for whom?
The respondent, my lord.
You are appearing for which respondent, Mr.
All the respondents.
All right, so we need not await. I thought you are appearing only for 1 and 5. You are appearing for all of them.
All the respondents.
Look here. The office notes is ignored in view of Mr. Mrigank Mauli, London Senior Advocate, appearing for all the respondents. Yes.
Your Lordship. Your Lordship, the appeal is against the order dated 3/5/19, parcel C.
Mic on, mic on. हो गया
189
Yes.
53 of 2013, Your Lordship. Your Lordship, in this case, the Honorable Single Judge has allowed the board to charge the final cost of the flat, which comes to 3,58,800 and odds. But Your Lordship, in the entire order, Your Lordship, the Honorable Single Judge has discussed about the revised price. Your Lordship, this is a case wherein the board has charged interest on delayed payment, Your Lordship. There is nothing with respect to revised cost, because even if...
Now, which part of the order
Your Lordship.
talks about that which you have challenged?
Your Lordship.
Which
Your
part
Lordship.
of the order? It's
Your Lordship.
50 pages order.
Your
You need to
Lordship.
point out
Your Lordship.
and then
Your
tell us
Lordship.
the background facts.
Your Lordship. Your Lordship, at the very outset, Your Lordship, this Honorable Court has relied on a case of this Honorable Court, which is with respect to price
What has
revision.
happened, Ms. Vinita? You need to tell us what
Your
is
Lordship. I'll tell.
Why are you
Your Lordship.
aggrieved by this order?
Your
What has happened? Why
Your
did Saraswati Roy come before the court? What happened? Mr. You are taking advantage of this order. Tell us what is it?
My lord, initially the petitioners, Saraswati Roy and others, she is a substituted petitioner, my lord.
Yes.
Originally, the petitioner had been allotted house on 20th of October 1984.
Yes.
Now, subsequent to that, 20th of October 1984, which is Annexure 1 at page 18, my lord.
Yes.
The father of the late petitioner Mathura Nath Roy was originally allotted that house, and subsequently he was substituted. My lord, Mathura Nath Roy was a retired judicial officer, and he had made an application for transfer of the name of the petitioner Mathura Nath Roy. The father's name was to be substituted and his name was to be added to the allotment letter. But subsequently, since it was not done...
Just a minute. Mathura Nath Roy was the original allottee.
No, my lord. Srinath Roy was the original allottee.
Srinath Roy was the original allottee.
My lord. Mathura
Then
Nath,
what happened?
And Mathura Nath Roy was the practicing advocate from this honorable court was, my lord, had made an application for substitution of his name since his father had died, and that led to a letter from the housing board in the year 1987 saying that if you pay the current price, then we will substitute your name in place of your father.
Was that the part of agreement with Srinath Roy?
No, my lord.
Is there any requirement of paying the current price over and above what price has been paid for substitution of the name?
No, my lord.
So did you challenge that? No,
my
you
lord,
did not.
that was challenged
Yes,
before
then
this
what
honorable court.
No, don't. I mean, we
We
are not categorizing.
My lord, we
that
just
is not
giving
the
an
way I
overall
think it
view
would-
of the.
Give us the overall view without my asking.
My lord.
Yes.
So, writ application 3924 of 1996 was filed, and pursuant thereto, the relief that had been sought by Mathura Nath Roy was that I should be given the house and my name should be substituted in lieu of my father's name at the rate that had been described in the original allotment letter,
Then
which
what
was just about 80,000. This honorable court took cognizance, gave them the notice, and then thereafter they agreed that they withdrew that letter of the current price, and then they agreed that we'll substitute our name in accordance with the terms and condition as has been described in the 1984 letter.
All right. Then?
Thereafter, by virtue of the letter that had been issued, this writ application was withdrawn and release agreement was signed, and the installment amounts had been fixed for 793 rupees. That had to be paid in 180 installments. Those installments were paid. Now, in the meantime, what happened was, my lord, that after the installments had been paid, the Mathura Nath Roy, the petitioner, wrote a letter to the housing board saying that now you execute that registered lease in my favor. Now, when that letter
Which is normally done after all the installments are paid.
My lord.
Yes.
So, not only 181 installments have been paid. Now, thereafter, they said that an amount of about 16 lakhs of rupees tentatively is due as against you for failure to pay all the installments. We are cancelling because those installments have not been paid. We are cancelling the original lease agreement that had been executed with you.
But you say that you paid all the 118 installments.
That is where the crux of the dispute lies, my lord. They said that I have not paid all the installments.
No, that's a question which can be, that's a factual situation which can be
Lordship,
decided
may
by
I-
the
They
records.
came out with in the counter, then we filed this writ application against that order of
What was
cancelling.
the stand of the board that you had not paid how many
My lord,
installments?
at page 93, my lord,
Tell
will
us
find in
first and then
paragraph
we will
4.
refer. How
There,
many installments you had not paid?
none, my lord, all 180 installments had been paid,
Their-
181 installments had been paid.
Their stand.
Their stand was, their stand was very vague. They said installments have not been paid. In paragraph 4 of their first counter affidavit, they said installments have not been paid. Penalty have been imposed for non-payment of those installments, and then interest was charged over that non-payment of the
All
installment.
right. So you challenge that.
My lord. So we had, by virtue of this writ application, we also had on record, my lord, all the 180 receipts against all the 181
That's true.
installments.
So what happened in the writ petition?
Now, in the writ application, my lord, their contention always was that we have increased the price in the year 1998 by virtue of a decision of the housing board in April 1998 saying that the price has gone up to 3,58,000. Now, that communication was never made to me.
Just at this stage, is there an escalation clause in the original agreement?
No, my lord, all that they said, they are relying upon one word, that the price was tentative.
All right. So that,
And that it could go up.
All right.
My lord.
taking your case at the worst and their case at the highest pedestal. So it was within the agreement for a re-evaluation of the price which Allotee had to pay. Nonetheless, what happened in that writ petition when you challenged?
This is the writ application which is under challenge before my lords in LP.
Yes, who is Saraswati Roy?
My
Wife
lord,
of late Matrana.
Wife of Matrana.
Then what happened? What has the court decided?
My lord, it has decided that since there was no notice that had been given to him, and this honorable court relied upon various judgments of this honorable court, saying that in case if there is no notice to the petitioner with regard to the escalation, it was highly unreasonable because the house was constructed as in the way back in the year 1987.
So let us not.
The court has considered that fact.
No, that's all right. That principle cannot be doubted. That if you did not have notice, and if the court puts the
even otherwise on merits, my lord, this honorable court was pleased to observe that the house was constructed in the year 1987 itself. It was ready. The price had not been ascertained even as on 1987. There was a writ application, interstate dispute between the parties before this honorable court. That was in the year 1996. They agreed to a price as on 1984. So till that time they could not have charged any interest.
And
now
their notice which you say you never received, which they say they sent it to you,
my lord,
this was in which year?
This was in the year 2007.
2007. Now ultimately when they threatened you of ejection and termination of the contract, you came before this court.
I came before this
with a
court.
plea that you are ready to pay the entire cost but not the interest on the delayed payment.
Though we challenged, initially we had challenged everything, my lord, but subsequently the writ court had directed us that we paid 3,58,000 as had been determined by the...
Show us from the judgment which part of the order or the judgment the court has taken evidence and has decided, taken evidence in the sense that he has relied upon that material to say that you did not receive notice.
My lord will kindly come to page...
Because if this is true, if the court agreed and allowed the board to charge you the price, the escalated price, the enhanced price, then perhaps delayed payment issue would be dependent on facts, right?
My lord.
So where has the court decided and on what material the court has decided? These things have to be pointed out by you, MS Vinita Singh.
Your Lordship,
Which paragraph, which line? Don't expect the court is expected to read all.
Your Lordship, no, Your Lordship,
but then
page 9.
Page 47.
Page?
Page 47. Last 3 lines.
Last 3 lines.
Now, the last contention of the Housing Board in reply to the submission that the petitioner was never informed and no notice was served upon the allottee about the cost of the flat, which has been increased after payment of installment. The submission was made that decision was taken in 181st meeting held on 30th of April 1998, which was notified in the form of office order on the notice board of the Housing Board. The notices were published in the newspaper calling upon the allottees to get their accounts verified by the board by producing the money receipts issued in their favor. The petitioner has annexed Annexure 10 in reply to the notice dated 27/6/2013, where he has not raised the plea that petitioner was not informed as being raised in the present writ petition. In the preceding paragraphs of the order, I have indicated that the Housing Board was not justified in notifying revised price on notice board after handing over possession of the flat. Similarly, the newspaper publication calling the individual allottees to produce the money receipt is again an eyewash. It was the duty of the Housing Board to maintain record and keep on informing the allottee if there is any default in payment and if there is any increase.
All right, para 29. Now, Annexure 11, what was that?
My lord will kindly have a look at Annexure 11, which is at page 200, running page 200. I'm sorry, that is not at page.
Running page 200, yes.
89.
That's Annexure 13.
My lord, page 89. Running page 89.
Running page 89, 189.
Just 89, my lord.
Yes.
उपर्युक्त विषय के संबंध में सूचित करना है कि बहादुरपुर पटना स्थित फ्लैट संख्या 100 जो आपको आवंटित है तथा दिनांक 6/8/97 को इकरारनामा का निबंधन कराया गया है कि विरुद्ध इकरारनामा निष्पादन के पश्चात किस्त की राशि जमा नहीं की गई है, जो निष्पादित इकरारनामा के कंडिका 24C आवंटन आदेश की कंडिका 13 का उल्लंघन है। किस्त की राशि जमा करने हेतु इस कार्यालय में विभिन्न पत्रों एवं निजी संपर्क कर अनुरोध किया गया है, लेकिन इन समारोह एवं व्यक्तिगत संपर्क के बावजूद भी आपके द्वारा बकाया किस्त की राशि जमा नहीं की गई है। अतः आवंटन आदेश एवं इकरारनामा में निहित प्रावधानों के उल्लंघन से आवंटन रद्द किया। दिस इज द ऑर्डर व्हिच इज अंडर चैलेंज।
That's right. How have you disputed this? किस्त की राशि जमा करने हेतु इस कार्यालय के विभिन्न पत्रों एवं निजी संपर्क का अनुरोध किया। विभिन्न पत्र, no letter has been produced by the board.
My lord.
Any letter intimating?
My lord,
intimating you.
If my lord will kindly have a look at page 203 and page 204, which is annexure 14 and 15.
Yes.
This was that letter, my lord, by which they had said that we had made paper publications.
Paper publication and pasting it on the notice board, all right. That the court has taken exception, it could not have been done.
My lord. So this
Now,
was the letter.
this is the
letter that they issued, annexure 14 at page 203, my lord, wherein they said ki you come over and get your accounts verified. This is the amount that is due to you. So in response thereto, Mathranath Roy had gone and met the executive engineer who had issued that letter, and they issued this letter annexure 15, which is at page 204. My lord will kindly have a look at the bottom of the page. This is dated 6/5/2006, giving a reference to the original letter, my lord. प्रतिलिपि श्री मथुरानाथ रॉय मध्यम आय स्वयं पटना को सूचनार्थ प्रेषित इकरारनामा के अनुसार सितंबर 97 से 180 मासिक किस्तों में शेष राशि का भुगतान करना है। अतः इस कार्यालय के पत्रांक 4/5/2006 द्वारा निर्गत मांग सूचना वापस लिया जाता है। आप मासिक किस्तों का भुगतान यथावत करते रहें।
ये कहां पर रहा है? Annexure 15 at page 204.
As I'm sorry, my lord.
कहां आपने पढ़ा? पेज 204 पर हमें
bottom of it, my lord, just below the letter number and the date.
Yes, below the letter number.
So they withdrew that letter 20, which had been issued on 4/5/2006 by this letter, which was issued on 6/5/2006, and I was directed to continue paying in terms of whatever had been decided by the original letter. And then the original letter itself said that the last paragraph it, अतः अनुरोध है कि अपने स्तर से माननीय उच्च न्यायालय के आदेश के तहत जांच कर संशोधित बकाया सूचना निर्गत करने की कार्रवाई करना चाहेंगे। The last paragraph of the substantive letter.
This is a letter sent by executive engineer to Rajaswa Padadhikari
of the housing board. So this was the original letter that had been issued by the executive engineer himself of the housing board. Then he withdrew this letter saying that there is no other dues, that you continue paying in terms of the original installments. So the original installment was 793, 181 installments we paid.
Where has the single judge dealt with it?
With regard to the paragraph that I read out, my lord,
therefore the demand was not pursued.
This demand was not pursued. It was only thereafter, my lord, in the year 2013 that they issued that letter annexure 11, by which they said that this is the amount that is due as against you because you have not paid the installments. Now, at no point of time
when did you respond? Why did you not respond after annexure 11?
My lord,
that this was the instruction to you not to pay anything except what was being paid by
my
you.
lord, that discussion is also there. My lord will kindly where has
the single judge dealt with it? That's an important piece of fact.
That the entire amount of the installments had already been paid by us.
No, where has the single judge dealt with these two letters and annexure 1? The single judge has quashed annexure 1, annexure 11.
Annexure 11.
Annexure 11.
My lord.
Must have relied upon annexure 15. Must have relied upon annexure 15. Where is the discussion?
My lord.
No, you're proceeding on the right
discussion,
lines.
My lord, he has taken note of during while recording this fact that these are the submissions of the petition.
No, he must have dealt with it. No, for quashing quashing annexure 11.
My lord.
The court perhaps what you have made us read.
There are two issues that this honorable court had dealt with. One was with regard to this fact that no notice was issued to him with regard to the installments. That was one aspect of it.
No, so that appears to be incorrect because there was a notice by way of annexure 14.
My lord.
right?
My lord,
So
but
that
none of them
notice
say-
stands liquidated, that notice stands withdrawn with annexure 15.
My lord.
The footnote.
My lord.
Not, the annexure 15 was not addressed to you, but the copy which was marked to you, there you were not asked to make any further payment. Therefore, that notice appears to have been rescinded.
My lord.
So therefore, where has the court said that in view of annexure 15, the stand of the board is incorrect, that there was any attempt to notice the LOT? I think this way the matter would, it will be shorter and easier to handle.
Your Lordship, may I submit?
We will hear from you. It's your appeal, we'll hear from you, but since they are taking advantage of the order, let us hear from them first. This is not the correct procedure, but for some reason or the other, I have asked him to. Where has the court dealt with it?
I'll come to that. My lord, probably the honorable single judge has not been, he has not dealt with those two particular letters, my lord.
Yes.
Those two letters have not been dealt with. They have, the honorable single judge has dealt with the letter that was issued in the month of December 2007.
No.
Which
Now
is at page 38.
You perhaps today would rely on annexure 15.
My lord.
For
14 and 15.
justification.
And then, my lord, even otherwise, what they are relying upon is annexure C to their counter affidavit, which is this letter dated 20th of December 2007, which came to us after almost 10 years. And this was in the year 1998 that they had fixed the price as 3,58,000, and they issued this letter to me, which we have said that we have not received, even assuming that this letter had been sent and had been received by us. Our contention was that it came to us almost 10 years after that they had decided that the prices have to go up. Now they have calculated the interest right from the period 1984 till 1998 and thereafter till 2007 and then till 2013. So what we were saying is that at any point of time, if they would have brought it to the notice of this honorable court, even during the course of the original writ application, 3924, 1996, there was no disclosure with regard to enhancement of the price, because then they were saying that current price has to be paid. So they had a calculation with regard to the current price.
So that is something which you expected as a sequel to this,
to
the discussion. But now come to para 30. Para 30 of the judgment.
My lord. It is significant to note that the tentative price.
However, quashing of annexure 11.
My lord.
Para 30, I think the numbering would be the same in your order.
I was looking at 13, my lord. I'm sorry.
30.
I'm sorry, my lord. Quashing of annexure 11 will not entitle the housing board to realize the amount, if any, payable by the petitioner against the delayed payment of installments. The housing board shall work out the details of the delayed payment and penalty for delayed payment and raise a demand for payment of the aforesaid amount within a period of 60 days. In addition thereto, the housing board may be justified in raising the difference of the amount already paid and the actual amount in construction of the flat, which has been worked out by the house board in a 181 installment, which has been highlighted in the counter affidavit as tentative price. The difference of the amount fixed at the time of handing over possession and the amount determined in 181st meeting shall be worked out by the respondent within a period of 60 days. And the difference between the amount of tentative price already paid and the price which was worked out in the 181st meeting shall be raised by the housing board within the aforesaid period, and thereafter within 60 days from raising such demand, the petitioner shall pay that
That's
amount.
right, we have followed that. Now, therefore, the court does not say that the board would not be entitled to calculate and saddle upon you the delayed payment interest, right? So, from which period to which period would it be calculated was the only issue left open to the board.
My lord, as we understood the order of the honorable court was that they were supposed to calculate 3,50,000 as they had decided in the meeting that they held on April 1998. So that came to 3,58,000. Now, as against the installments, if we have failed in paying the installment, they are entitled to a penalty thereon. Now, they have given a calculation chart.
From which date?
My lord.
From which date?
The dispute was what they were saying, my lord,
Right from the beginning.
Right from the beginning.
That was unjustified.
Their basic
prima facie, but then
their
thereafter-
basic contention was that why I have defaulted in payment of the no, I'm just trying to explain as to why this this writ application and this LPA had come into being, my lord. Their contention was we have calculated that 16 lakh amount or 3,58,000 was the price. Now based thereon that you were supposed to pay the installments. But the fact remained that in the year 1984, the installment that had been fixed was 793 based on the price they had calculated in the year 1984, which came to 80,000.
When the house was already constructed.
87, there is a letter to that effect, my lord, at page 200, saying that that house is already constructed, water supplies have already been given, now you move into it, take possession of it. So that is 87. Their contention is that we have already enhanced the price, you have not paid the enhanced installment.
So the court has not agreed that part of the...
So penalty amount, we are agreeable to it based on whatever the installment that we were supposed to pay 793, and they have given a calculation chart, only 9,000 rupees that was due to us, due against us.
After this judgment, they have given you a chart.
No, my lord. Even during the course of this writ application, they have given a chart which is part of the counter affidavit saying 9,398 was what
which
was
you are
due.
ready to pay.
My lord, that is all that I am supposed to pay, and they have charged an amount of penalty about 14,000 rupees thereon.
Yes, I must say.
Your Lordship, this was a scheme for 288 flats, Your Lordship. So as and when the flats were being constructed, possession was being given. Your Lordship, after the entire completion of the project in the year 1998, the board held a meeting and the cost of each flat came to 3,58,800, Your Lordship. Thereafter, the board, as per the counter affidavit, Your Lordship, we had affixed the amount which was to be payable after deduction of the original amount decided as per the hire purchase agreement, because that was a tentative cost and the final cost was to be ascertained after the completion of the entire scheme, Your Lordship. Thereafter, Your Lordship, there was no payment, but the board brought on record on the query of the Honorable Single Judge the receipt and the registered receipt whereby in 2007 the petitioner had received that now the amount of 6 lakhs was to be paid in view of non-payment of the additional amount. So that after 2007, Your Lordship, this Honorable Court has said that the board has kept silence for 9 years. Our submission in this is in the LPA is that even after 2007, till the cancellation, the petitioner also did not come forward to pay the amount which was decided or to get it adjudicated or to understand as to...
We do not appreciate that contention.
Okay.
on board.
Your Lordship, so
But
after
this
2007, several reminders were given, and with the enhancement, thereafter, Your Lordship, this Honorable Single Judge has relied on a judgment which is not at all applicable in our case, because in our case,
we are not,
Your Lordship,
judgments would not cover
Your
the
Lordship,
appeal.
Your Lordship, then
Now,
Your Lordship,
just a minute.
Ji.
Now, how do you justify, and what is your answer to this letter dated 6/5/2006 contained in Annexure 15 for you to agitate now after the judgment of
Your
the
Lordship, that letter was not correct, because thereafter in 2007 we did, that was in 2006, that thereafter the board informed that in 2007 that an amount of 6 lakhs and odds have to be paid.
Where is that correspondence? Where is the evidence that it was the allottee was put to notice?
Your Lordship, that is annexure.
Anyway, what
That is there, Your Lordship, annexure L to the fourth
now-
supplementary affidavit.
Now, what is expected of you to?
Receipt of registered
Just a
post is
minute.
also annexed.
Now,
Your
give us a 2 pages fact sheet giving the stages at which you gave a notice of the escalation of the escalated price. They did not respond, and similarly, Mr. Mrigank Molly, you would also give a 3 pages fact sheet for orders. We keep it for orders on Wednesday.
Lordship, it may come on Monday, Lordship.
So you are ready with the brief? What is the matter? We will.
Wednesday is
You
tomorrow,
just need
Your
to give a 3 pages fact sheet.
My lord,
Both
we'll
of
do
you.
that. In fact, my lord, during the course of the writ application, both the parties had filed their written submissions. Or probably that would be.
That's a stale one. Now, after this judgment, give us a fact sheet of 3
My lord,
pages.
we'll do that.
We give you
My lord will give us some more time than that.
some more time. So we are fixing it on Monday for orders.
Much
Or under the same
much
heading.
obliged. Much.
But you give the fact sheet latest by Friday,
My lord, we'll do that.
Online.
right?
Online, no.
Online.
Your Lordship, because that day the court would not be there. Oh, we'll
Friday
send
you
it.
give it to my court, both of you would give it to my
We'll do that.
courtmaster.
Oblige.
You're not keeping it online.
Nahi, we'll come and give.
Or if you can do that early, you can file
We'll
it
do that,
online,
madam.
we will have it downloaded.
As early as possible, we'll try and do that.
Friday,
Madam.
should be before Monday.
Madam, we'll do that.
Your Lordship, only the stages on which notices were given to the petitioner for the, Your Lordship. Oblige.
The learned counsel for the parties have been requested by the bench to provide a fact sheet in short indicating the stages at which notices were sent to the allottee / the respondent and the evidence in support of such notice having been received by the respondent. Mr. Mrigank Moli, learned counsel for the respondent, would furnish would furnish the stand of the allottee with respect to the receipt of the notice. Re-notify on Monday.
4th of July.
Oblige.
We have only asked for a small thing, but you have to give the fact sheet of the entire case.
Madam.
And it must be referable to the facts stated in the order.
Madam. And the running pages.
You know how the fact sheet is to be prepared. What is the case in one paragraph, and thereafter where is the decision, where this point has been dealt with by the London single judge, what are the materials, annexures, corresponding references.
Madam.
You need not write it,
Madam.
but corresponding references with the page number.
Oblige.
Seal 4, Mr. Vinay Kumar Pandey.
Yes, who appears?
Seal 4, Mr. Vinay Kumar Pandey.
इसके स्टूडेंट और इनको तो कह दिया कि मुझे तो चैलेंज नहीं करेगा तो अपील कहाँ से? Who appears for All India Institute of Medical Sciences? Such an important matter, it is not being attended. Who is the advocate? Anyway, nobody appears.
Vinay Kumar Pandey.
On behalf of the appellant, on repeated calls, re-notify on, give a date on Monday.
4th of July.
Inform the council. It's an important aspect. It would foment further litigation unless it is decided. Inform the council that the case was called out. Yes, next.
Seal 5, Mr. Mukund Mohan Jha.
There is a delay of 286 days in filing of the
We condone the delay.
Mike.
Delay we don't bother unless it affects your rights. IA number 1 of 2021 लिखना. For the reasons stated in the application, the delay of so many days in preferring the appeal is condoned. The application stands allowed. Yes.
My lord, the only one issues, my lord, where the Sogra College teacher training college is valid or not, my lord. That is the issue. My lord, kindly see the order dated, my lord, 16/1/2019. My lord, the learned counsel.
Who appears for the state?
My lord, I am for the state, my lord. The state appeal, my lord.
This state appeal.
Yes, my lord.
Now, have you impleaded this
Yes,
lady,
ma'am.
Nishat Zareen?
Yes, my lord.
Let notice be issued to the respondent on steps being taken by the appellants within a period of 2 weeks, both modes, returnable on 6 weeks.
All right.
3rd of August, 10th of August.
You're not going to disturb her in the meanwhile.
Yes, my lord.
You're not going to disturb her in the meanwhile. She continues to teach.
My lord, since I have filed a stay,
No,
an application for a
that
stay.
IN number so and so. Seeking
My lord, I am
stay-
not pressing at this
No,
moment.
seeking stay of the operation of the order passed by the learned single judge shall be considered at the time of final hearing of this appeal.
Seal 6, Mr. Prabhat Prasoon. 6.
Yes, sir.
For Monday.
हाँ, ये है क्या, पहले ये बताएं. What are defects number 10, 24 and 49? We will ignore such defect. What is the order? ठीक है, मंडे को आप बहस करें.
मंडे को रख दिया.
As prayed for on behalf of the appellant, re-notify on, give a date on Monday.
4th of July. Serial 7, Mr. Satyavir Bharati.
Yes.
May it please, Lordships, yesterday this matter was taken up. The appeal has been preferred against the interim order passed by the learned single judge, wherein
yes, she was addressing the
my lords had directed us to inform whether what steps has vigilance department has taken pursuant to the orders passed.
Why are you challenging this order?
Lordship will see the order. It has made scathing remarks
Not
on the board.
at all.
If your Lordship will see.
Not at all. It's only tentative. Now read that part of the order which affects you adversely.
If your Lordship will see paragraph 2, under the aforesaid circumstances, the court is of the considered view. It is not even prima facie. It is of the considered view that such manipulation is not possible without the active connivance of the officials and employees of the Bihar School.
Therefore, in order to purge yourself of this scathing comment, you need a full-fledged inquiry, which has been ordered by this court.
Inquiry could have been directed.
Otherwise, how could this thing happen? Unless, I mean, does it speak about the chairman of the board or the members of the board? No, the functionaries of the board.
Yes.
Now, if something is stated about the High Court, it is not an attack on the judges. It is the way how the registry functions.
Yes.
Right? So therefore you need not be so sensitive. If that is the cause of your concern and that's the reason for your filing the appeal, we are dismissing it. But unless you tell us that there was some investigation of some kind as directed by the learned single judge and there is any report.
Lordships, we have tried to find out. We have the vigilance department has.
Who appears for the state?
Has not communicated any inquiry which was
now,
conducted.
how is that possible? The additional director general. आप स्टेट की तरफ से कोई वकील है ही नहीं है. Why have you to look askance when the court is asking for a state? Please inform the advocate general. No lawyer is there, and the lawyer who is there, who is sitting in some other case, is not ready to accept notice. MS Vinitha Singh, you are a standing counsel. When I ask for the state and you find that there is no state counsel present, is it not your duty to come and assist the court?
Your Lordship, I was paging it,
all right.
So I didn't hear.
So all right. Otherwise, we would have asked the advocate general at least to allot one counsel for this court.
No.
Now find out from the additional director general of vigilance, cabinet vigilance, who appears for the vigilance department.
Ms. Khoprikar, Archana Khoprikar and Mr. Ramakant.
Inform Mr. Arvind Kumar. You inform Mr. Arvind Kumar, MS Vinitha Singh. Find out and tell us tomorrow orally what has happened pursuant to the order passed by this court. Give a copy of that order to her.
Lordship, I'll give it immediately. Supply.
We are not concerned with that remark. You may be concerned, but we don't find it to be a scathing.
We were aggrieved by the fact that we in the right earnest took up the matter.
I think you would be well advised to participate in the investigation, find out who the culprit is, and put him to task.
If that would have been the logical thing, but the learned single judge, the very first paragraph says that you are involved and therefore we are directing inquiry.
It doesn't say.
That is
the meaning of the expression used by the single judges, that it appears that's silent.
It should
that
not
is
have
silent.
Been there. Once an inquiry.
Lordship, in item number 4.
No,
yes.
Not in 4. Not in 4.
7.
MS Vinitha Singh, don't run away from the responsibility.
No. I thought he is here.
Even if he were there, if the court has asked you, the court has instructed you, you do the needful. Find out, ask the vigilance department to inform him and you as well what has happened. Then we'll decide.
Select Mr. Mohammad Imtiaz Hussain.
Passing it over.
We are just passing it.
Select Mr. Mohammad Imtiaz Hussain.
Yes.
Lordship, this case was yesterday taken up and the counsel who is conducting the case is in fact wanted some time because I'm not praying for time. I'm fully prepared. The thing is that he said that the connecting reed is not available with him.
Connecting?
The connecting reed of this is an LPA in which actually the connecting reed is very much required. But in fact,
can't understand. Connecting link.
Reed application.
Connected reed.
Reed. The connected reed was not available with him. The learned counsel who is conducting lawyer.
No, what do you want actually?
So
Tell us.
actually he wanted some time. I have also not seen. But yet your
What is
lordship
the
wanted
matter?
to hear the merit of the case. So he said that you at least argue the merit of the case, and when I get the connected reed, I will
Which reed?
I will give it to you.
Now,
The
connected
matter of the
writ is a
case
vague term. This order has been passed in a writ petition. Now, which other writ?
The order has been passed on read petition, but in read petition actually there are many annexures which I wanted to read because he has engaged me.
We have the.
But he said that
Records
I
of
do
the
not
writ
have.
petition.
So if it is supplied to me next time I can argue, but still I do not have right now.
Only two annexures are there in the main writ petition, but then we'll give you time. You'll find out.
Because what he has given me right now is that he has
All right,
given me only the copy of the LPA.
All right, we'll hear you on Thursday. 2 days good enough to see two annexures. No, please don't.
After Tuesday?
Please don't have the case fixed according to your calendar. Go by the calendar of the court.
What is the date likely to be given?
Thursday.
Thursday of this week.
Yes, day after tomorrow.
Okay, let me see if he can arrange the, but within that time certified copy would not be.
No need of certified copy. You can.
Because he
hold-
says that whoever has given me the read, actually he has not, the LPA, he has not given me the
Mr.
copy of the read. Anyway, should I argue the case? Should I say the merit, submit the merit of the
Be
case?
absolutely satisfied about what you have to argue and then argue.
I am
please-
actually, I need the copy of
Yes,
the.
we have heard that. You need not repeat it all over again.
He says that you argue on the LPA. Okay, I have got it.
Yes.
So in this case, what has happened is there is one college.
Yes.
Its name is National Teachers Training College. It is in Khajanchi Road, Patna.
Yes.
It is in Khajanchi Road, Patna. Now they offer degree of B.Ed, Bachelor of Education. Now they intends to run a course of DLA. Diploma in Elementary Education, DLED. They said DLED. This course has very recently come, and they said that we would run this course. Now, if you want to run this course as DLED, then you have to have a recognition from NCTE, that is National Council of Teachers
That's all right.
Education,
You proceed ahead,
which is
please.
there in Bhubaneswar.
Yes.
Now, accordingly, he is applied. He has submitted a fee of 1.25 lakhs, and whatever necessary document they wanted, he has submitted. Now, what happened on 22/12/2016? They demanded few more papers. What papers? They wanted the approved plan of the PRDA of the building what is getting constructed there in the Khajanchi Road. They wanted no objection certificate of the Patliputra University to which this institute is affiliated, and they wanted the fee structure to be given in chart, that 1.25 lakhs, how have you submitted? Now these three papers actually they wanted, NTC. Now the problem is that all of a sudden the father expired of the petitioner, and the son has also expired. He had some problem expiring in the family. So what he did is on 19/5/2015 he applied for postponement of date, that you give me another date so that I appear, I bring this paper and submit everything. But instead of, Lordship, am I?
Yeah, we are hearing you.
Lordship. Now the thing is that instead of postponing the date, the
They closed the
committee.
file altogether.
Lordship.
They closed the file.
They closed the
altogether.
file. They said, no, we will not postpone. We have simply closed the file. Now, against the closer,
We have followed that.
Lordship, against the closer, they went to the appeal.
We are
Appeal what they have.
We are skipping that part. Now hear the court first. We are skipping that part of the order,
Yeah.
that part of the development.
Yeah. Now,
just a minute.
Lordship.
Your application for recognition was rejected.
they closed the file and actually rejected.
You filed a statutory appeal.
Appeal.
That also was rejected.
Yes, on the same grounds what they have taken.
And you say that you could not pursue the first application and the appeal because of sudden deaths in your family. Series of deaths, all right?
Oui.
Now the court has been cautious. The court says that you apply afresh. Now, assuming but not admitting the fact that this order, we don't find any fault lines in the order, but suppose we do away with this order, your recognition would be from a prospective date, not from the retrospective date. Is that okay? Is that proposition right?
Retrospective
Now,
date.
in that event, try and understand what the court is saying. Don't just remain stuck to your ground which you've prepared. Right? So, therefore, this order does not affect you adversely at all. Have you followed why?
I am following.
Those are, even if we set aside the order or we direct the ERC, NCTE, ERC at Bhubaneswar, to decide your matter and not take it as a closed file at your instance, and if they decide to give you recognition, that would be from a prospective date. All right? So therefore, you would be well advised to file a fresh application for recognition, which they would be under an obligation to see and decide. Why should we interfere with this order?
Lord, am I allowed to speak something
please.
Or you submit something?
It's your case.
Otherwise,
yes,
no,
yes.
otherwise Lordship said, do not interfere when I am arguing, when I am putting my time. The thing is that I have deposited a fee of 1.25 lakhs. I have deposited the no objection certificate they wanted.
Mr.
Now,
Singh,
Lordship.
just a minute. You need not, when the court is asking
Lordship,
question,
one more submission.
Please.
Oh.
Mr. Singh, would it be okay if we direct that the amount which is deposited shall be adjusted in the fresh application?
Lord, clause 5 of the regulation 2014 says that once the rejection is made, the fee is forfeited. He has to apply a fresh.
So he loses his 1,25,000 and the
Because Lord,
possibility of
the institution is closed for more than 5 years.
Oh.
It was rejected in 2016, and in January 2017, he gave a petition to close the file. They are not mentally prepared to conduct an inspection.
That's all right. He says that it was only for.
And in paragraph 10, Honorable Single Judge has given this liberty to
We have
him.
seen that. We have seen that, therefore we have confronted
In
him
paragraph
with
10, he says that he can, accordance with if legally permissible.
that. Yes, I forgot your name, Mr. Counsel.
My name is Ravi Shankar Ganguly.
Mr. Ganguly, now we were.
I was sick actually, only your Lordship has allowed me to go to AIMS and come back.
All right. So, Mr. Ganguly, we were contemplating that if it was acceptable to the NCTE, we would have asked them to adjust this amount of 1,25,000 in the fresh application which you have filed, which you would have filed for your recognition. But as he says, the amount is forfeited with the closure of the file. Now 5 years have passed by. We may not be legally, correct in directing him to adjust the amount. So that amount you have lost.
Lordship, should I say something? With the permission of the Honorable Court, I have got two submissions. The first submission is that they say, we are continuously in interaction with them. They say that if the court says that you adjust this amount, then we will adjust. Number one.
This is what.
Now, what he says is correct.
Without,
what he says in clause 5.
Without your argument, did I not ask this question from the NCT
Lordship,
lawyer?
Lordship.
Then?
Lordship, I am coming to the point only. Lordship has beautifully come with the conclusion that if we say that you adjust, then they have to adjust. Number one. Number two is that the great difficulty what we are facing right now is that the portal what is there is not being opened. The portal is constantly, I found that is closed. And they will not open the portal because the case is closed.
That point I must say,
the
government of India has taken a policy decision that it is a pan-India policy, Milord, that the portal has been closed. It is expected to be open in near future, Milord.
Why you're not allowing any?
From 2019, Lord, we are not allowing any further recognition.
Has this decision got something to do with the corona?
No, Milord. It is the policy now, Lord, in new education.
Policy has to be. There has to be some basis for.
No, new education policy. They are going to introduce a 4 years integrated course, and in this year, Milord, they are going to initiate.
Otherwise, also, so they will come up with new plan, new fee structure, new amount. So therefore, that is lost.
Milord, now that advertisement has already come for 4 years, although it is for 50 pilot project they are going to start, Government of India, across the country.
So at present it is closed, but I expect not in near future it will open.
Yes. What he says is to extent is correct. In clause 5 it is written that it is forfeited, but with the order of the court, this court has enormous power. The court can do it. Number one. जैसे हम लोग सुंदरकांड पढ़ने से पहले किचकिंदा कांड पढ़ते हैं, so that कि सुंदरकांड में आपको इतना पावर है. We read Kichkinda Kand and then we'll go for the Sutkanda. So what I am doing is I am reading Kichkinda Kand. This court under Article 226 had got enormous powers. The clause 5 gone under Kichkinda Kand. Now coming to the point. Coming to the point is that the court has beautifully come to a conclusion, and I am also I have to agree, and I agree. Let there be a direction to adjust the fee, open the portal, and if it is not possible, then let there be a fresh inspection. I am ready for the inspection now. If there is an inspection and they pass an order, and if it is not in my favor, I will come to the court, and if it is in my favor, I will be happy, I will be very much obliged to the court. So I seek a direction of this honorable court to give a direction to them to inspect my organization, because I have got an approved plan, I have got 2000 all NOC certificate, everything. Inspect, pass an order, and if I find that yes, it is acceptable to me, I'll accept. I will find it is against me, I'll come to the court.
That's Mr. Ganguly, that is not possible. That is not possible now. We would have been happiest to do that, to order that, but it is not possible because now it is closed. Now any institution which has to open and which has to have the recognition of NCTE has to have the infrastructure and model for a 4-year integrated course. Now this 2-year DLED course is over.
That is why what Lordship is of opinion, I admit the opinion of the Lordship is a very fine opinion that new course is coming. Now let them inspect and give me a perspective. And I will take the admission of the new students. And if the students are there with me, I will say immediately, now 4th year's degree course if they say, but that has not come to us. No such notification has come to us. So let there be a direction, Lordship,
Mr.
to
Ganguly,
inspect and pass a fresh order.
We are sorry, we can't help it, notwithstanding the fact that there were some mishaps in your family, and we were trying to soft pedal the issue. We could have asked the NCTE to have adjusted the amount, but with the forfeiture of the fee because of closure of all such process and new education policy, new system of elementary education on the anvil. I'm sorry, we can't. Let
me give. If it is posted for another week time, I will give some beautiful ruling of the Honorable Supreme Court. Now the Supreme Court in many cases has said that if it has passed, Lordship, with the kind permission, if I am allowed to speak 1 or 2 words for my satisfaction. Now the thing is that I have deposited a fee of 1.25 lakhs that your Lordship has. I have invested a lot to construct this institute. I have invested about 8 crores by taking loan from the bank. Now everything is riding on my head. I have given a heavy installment. I seek only one direction of the Honorable, one direction, that let there be a fresh inspection and pass an order. And if that order is against us, we will come.
That scope
but not by his submission that please close.
No, that scope is closed now.
Could the court in Kichkinda Kand, the court has enormous power. The court has enormous power. Our subclause 5 does not stand before clause 5. The court has got enormous power to say that inspect afresh, pass a fresh order, and if you find that it is not as per your terms, you pass a fresh order. But till such time it is inspected, how can they pass an order? Now I would also submit 2-3 things. Here they say, in the appeal what they say, that you have not given a proper PRDA plan. This is wrong. In PRDA, actually in Bihar, PRDA actually did not give certificate. It is the certified engineer who gives the certificate. In Odisha, the systems are different. Anyway, but that dispute could also be over. If there is an inspection, PRDA people will go and say that yes, we give through the certified engineers, everything will be done. So I humbly submit, very humbly submit to pass a direction for a fresh inspection and pass an order, so that I get the recognition, and the students who have already I have taken admission they could also get a recognized.
That if you have taken admission, you have committed a fault.
No, no, we have never assured that we will give you a certified degree. We will say that we will educate you.
Don't make that statement before the court. That goes against you.
Yes.
You cannot take admission.
I cannot take admission for this course. I can only say that this is the syllabus we can teach you. But we cannot give you a certificate of recognized course. This we have assured. But Lordship, what I pray is that there is only one line direction of life. This is a very simple left-hand job for your Lordship. Give a direction, give a direction to inspect afresh and pass a fresh order. I have got all the papers with me.
Mr. Ganguly, no matter how much pep talk you may give about the powers of the court, we refuse to get excited and pass orders which are beyond our jurisdiction.
Lordship, I have to excite something. Sometime if I do not excite, sometime initiate.
Heard Mr. Ravishankar Ganguly.
Lordship, you please, Lordship, I humbly submit to either to, if I apply, let the portal be open. Portal is closed, how can I apply?
We will refer to that.
The direction of the Honorable Court says that you apply a fresh, but how can I apply? The portal is closed and I adjust my fee. Both the options are.
All right, you have argued your case to the best of your ability. We appreciate. Now allow the court to pass the order.
The thing is that there are two words, good and bad. If the last thing goes with me, then it is entirely bad. I am not a good submitter. I do not submit everything that is good. The bad prevails on the good.
Heard Mr. Ravishankar.
The bad prevails on the good. So whatever good I have, everything is bad if I fail.
Heard Mr. Ravishankar Ganguly, learned advocate for the appellant, and Mr. Sunil Singh for the NCTE. The appellant institute had come up before this court against the order passed by the Eastern Regional Committee refusing to grant recognition to the institute for conducting DLED course, as also the decision of the appellate authority sustaining the decision of the NCET in not permitting in not giving recognition to the institute. On behalf of the appellant institute, it was argued that because of certain mishaps in the family, the matter could not be pursued further, and a request was made to the NCTE for postponing any decision making on the application made by the institute for recognition or revaluation of the decision refusing to give recognition to the institute. However, taking a different view of the matter, NCTE found that the management of the institute was not interested in pursuing the issue of recognition and closed the file. An year after the aforesaid closure of the proceedings before the ERC of NCTE, the appellant institute preferred the writ application, the aforenoted writ application, namely CWJC number 7735 of 2020, which was rejected, the learned single judge rejected the prayer made therein by the order dated 14/12/2020, but not without giving an opportunity to the appellant institute for approaching the NCTE afresh in case so desired, when the NCTE was expected to take a fresh decision in the matter. Mr. Ganguly, however, has argued that in anticipation of grant of recognition, necessary infrastructure upgradation was made in the institute, which already had been running for B.Ed course. The letter of postponement of proceeding, it has been urged, ought not to have been treated as representing the animus to have the proceedings postponed forever. Mr. Ganguly further contends that the institute would be satisfied, that the management of the institute would be satisfied if the fee which had already been paid by the institute for the purposes of recognition by NCTE is adjusted against any fresh application which shall be made by the institute for recognition for future sessions. Mr. Sunil Singh, Learned Counsel representing the NCTE, however, submits that with the closure of the proceedings, the fee stands forfeited in view of clause 5 of the rules of the NCTE.
Regulation
Clause 5
2014.
regulation. He further submits that under the new education policy, a new DLED course is on the anvil, and therefore the government of India has taken a decision not to give recognition to any institute in the interregnum, that is before the new policy comes into play. Precisely for this reason, the national portal of the NCTE is not open for any fresh application to be made by institutes. Under the aforesaid circumstances, this court finds no justification to accede to the request made by the appellant for directing the NCTE to adjust the fee paid by the institute for consideration for grant of recognition. We, however, reiterate that in view of the new education policy and new course curriculum introduced under the policy, the petitioner institute shall be within its rights to apply for recognition, and if it does so, after fulfilling all the conditions, no adverse view about the institute shall be taken by NCTE for the institute having failed in getting recognition
Lord, I must clarify
in the
one
past.
thing.
Yes.
That 4 years course, a portal has been opened, but this is exclusively for government institution. Only 50 colleges में ही ये लोग दे रहे हैं as a pilot project.
However, it is clarified by Mr. Singh, Learned Counsel for the NCTE, that under the new policy, only 50 institutes as pilot institutes have been
of central government and state government.
of the central and state government have been notified, and the petitioner and the appellant institute shall have to wait for the extension of such policy of recognition to other institutes. Uske baad wahi likha. With the aforesaid observation, the appeal stands disposed of. Yes.
Seeing none, Mr. Mohammad Irsad.
Lordship, just actually he has assisted me. Let his name Imtiaz Hussain be added along with me.
Lordship, Mr. Ravi Shankar, these are unnecessary. Just a minute, these are. Let me just ask him, Mr. Imtiaz. These are unnecessary prayers. It's an embarrassment to the court. It's an embarrassment to others. Otherwise, you should have given a slip. Your name would have been there in the footer, in the header. The court only takes reference of the name of the advocate who addresses him, not of the entire team and the battery of the lawyers. Now that's not done, Mr. Imtiaz. If you have been a practitioner of this court, you can file your slip. You would be knowing this. You can file a slip and your name would be there in the order sheet.
Lordships, I'm very
Anyway, when you have made this prayer, let me accede to such request. Mr. Ravi Shankar Ganguly, assisted by Mr. Imtiaz Ahmad.
Lordships, I'm sorry, item number 4, it has been adjourned for 4th July. No problem, I will be appearing. Only, Lordships, I was here, but case call ho gaya. No one appears likha gaya.
No one appears. We will hear you tomorrow. It's an important matter.
Obliged.
Now, have you challenged that, Mr. Pandey?
Lordships.
Have you challenged that order, that decision of the government to whereby rule clause 6(1)(a) or whatever has been modified? No, you have not.
No, it is in the LPA, Lordship. We have
Again,
stated.
Mr. Pandey, you are not understanding what the court is
Lordship,
saying.
the decision.
The decision of the government,
Lordship.
it was in the first instance required to be challenged by AIIMS. Now, I don't understand the logic for this amendment in the clause. This was pursuant to a direction of the court for clarification.
For clarification.
But clarification of this kind, that was not this. That would not have been that would not be the subject matter of the appeal here. No. The decision by the single judge is based on a decision by the government to clarify. To make amendment in the rule.
Lordships.
Now the rule has to be challenged by you afresh. Where would the appellate court? You're not understanding. Where would the appellate court get the opportunity of disturbing the judgment of the single judge in view of the decision of the government? So therefore, the government's decision has to be challenged by AIIMS. That notwithstanding the fact that AIIMS is situated in Patna, which is the capital of state of Bihar, the students passing out from AIIMS would not get any opportunity of participating in the NEET in Bihar. If you are interested about your own students, you would take proper precaution. LPA is all right. LPA is against the order passed by the single judge, which says that now with the clarification made, AIIMS students are excluded. So far so good, because there is a decision of the government. Now that decision is required to be challenged. Where do you need to file appeal for that?
Yes, Lordship, no, ठीक है,
Then we will dismiss the appeal and we will not even give you the observation. You represent AIIMS, which is one of the most important educational institutions in the country.
Lordship, I got your Lordship's point, your Lordship, that the decision has to be challenged afresh, separate, not separate.
This LPA, and we would have said that this appeal would await the result of the
result of that. Yeah.
So ये advice put करेगा.
No, Lordship, this is not. I am very well tomorrow.
मार के तैयार होकर आइएगा कल. Tomorrow. कर देना उसको. Nobody appears.
Tomorrow.
Think on those lines.
Lordships,
it's an important aspect of the matter. Why should students of AIIMS suffer? There does not appear to be any rationale behind that decision of the government. But nonetheless, that is for the government. You represent the government or the AIIMS?
AIIMS, Lordships. I represent all Indian School of Medical Science.
Anyway, we'll ask the state of Bihar also. But should you come with that plea then
Lordship,
only?
all that.
Yes. Tomorrow.
Tomorrow, Lordships. Obliged.
Sinan, Mr. Mohammed Irsad.
Yesterday, your Lordship was
Louder.
Yesterday, your Lordship was directed to seek instruction whether order has been passed under Section 9 and order has been passed under Section 9. But, my Lord, in Section 5,
nothing can.
Warrant of arrest has been issued, my Lord.
So nothing can be done. You have to go again. Public Demand Recovery Act Section 9 के बाद.
Section 60.
Did you appear? Was a hearing given to you under Section 10?
Under Section 10 has not been under passed. I have appeared.
नाइन का डिस्पोजल हो गया तो 10 में ऑर्डर पास हुआ होगा सर. 9 में अपीयर कर गए हैं, ऑर्डर पास नहीं हुआ है 9 में भी. 9 डिस्पोजल होगा तो 10 हो गया. हाँ, तो 9 को ऑब्जेक्शन को डिसाइड कर दो, 10 में हो गया. पेंडिंग ही है 9, तो आप बोल रहे हो गया. हाँ, वो ऑर्डर पास नहीं हुआ.
1 करोड़ का सर्टिफिकेट। After this order, the petition, the order was passed. After this order passed by the single judge, the certificate officer passed the order under section 10. Yes. After this order, yes, sir. Then what can? तो इसको अपील अब क्या करेंगे? ये तो this has lost its force. It was executed. This order has been executed. You have to file afresh. This appeal no longer exists. In the meantime, distress warrant, fresh application file करना पड़ेगा आपको. Challenging the order passed under section 10 pursuant to the order passed by this court. इस order को आप challenge करके क्या करेंगे आप? That is what I wanted to know from you. Perhaps you have not taken correct instructions. Otherwise also, if the order has been passed against you under section 10,
under section 10 has not been passed.
नहीं कैसे नहीं होगा? 9 में पिटीशन फाइल करते हैं, सेक्शन 10 में ही ऑर्डर पास होता है, जो आप खुद कह रहे हैं कि आपने फाइल कर दी, वो ऑर्डर पास हो गया. तो ऑर्डर जब पास हो गया तो अदरवाइज ऑल्सो यू आर रिक्वायर्ड टू fulfill the obligation. Now the court has only said that distress warrant would be done away with if you deposit 15% of the certificate amount.
I am ready to pay.
But now the order has taken its effect. ये 15% then distress warrant जब 9 में जा ही रहा था distress warrant. Yes, Mr. Alok Ranjan. If the learned single judge was directing the petitioner,
yes,
the appellant,
yes,
to make necessary representation under section 9, yes, then where was the justification for saddling him with 15% of the certificate amount? That would have been dependent on the decision of the certificate officer under section 10.
Your Lordships, at that point
this is an unnecessary addition, because he did not represent and he was a fugitive for all this while, 10 years, 12 years or so. Therefore this order. But otherwise we don't. Can you place before us the order passed by the certificate officer? आप ऐसे blank expression देते हैं, आपको मैं मदद करना चाह रहा हूँ, आप कुछ करेंगे ही नहीं तो क्या
दे देंगे?
उसमें आपके पास है वो order. We are exceeding our jurisdiction in appeal because you are not effectively representing your appellant. अभी है आपके पास? अगर सर्टिफिकेट ऑफिसर ने आपकी देनदारी फिक्स कर दी होगी तो ऐसे भी देना है तो 15% को क्यों हम इंटरफेयर करें? The order has taken effect, Mr. Counsel.
अभी फाइनल ऑर्डर नहीं लेकिन पास
नहीं पास हुआ है?
नहीं, अभी खाली रिजेक्ट कर दिया मेरा ऑब्जेक्शन पिटीशन से.
That is the final order, Your Lordship. Rejecting.
That is the final order.
Reject under section 10, Your Lordships. The section
That's
9
the
objection.
final order.
Now section
Now
60 is there.
It is only left to be executed. All that we can do is, there is no time also has been given by the single judge. ये देने की जरूरत क्या थी?
नहीं, उसको time दिया हुआ है.
Within period of 3 months.
3 months.
3 months have passed by.
Yes,
2012, so long time back. This appeal was filed in 21.
A delay of 60, more than 60 and under 10 days is there.
We will not be able to help you out now. We will not be able to help you out.
With due to illness of the.
नहीं 2016 से illness नहीं होगा.
16 से help लगातार. Page 30.
Sorry, we can't. I'm so sorry.
16 से 18 तक हम बीमार रहे.
Mr. You are Sanjeev Kumar.
Mohammad Irshad.
Mohammad
Irshad.
Heard Mohammad Irshad, learned advocate for the appellant, and Mr. Alok Ranjan for the state. By the order impugned, dated 20/12/2016, passed in CWJC number 15088 of 2016, the learned single judge allowed the appellant to file his objection petition before the certificate officer under section 9 of the Bihar and Orissa Public Demand Recovery Act, even when the proceedings had been pending for several years by then, and also state the distress warrants dated 16/3/2016 as well as bailable warrants dated 21/3/2016, 5/4/2016, 18/4/2016 and 21/4/2016, subject to the appellant depositing 15% of the certificate amount within a period of 3 months from the date of passing of the order, bracket 20/12/2016. It was clarified by the learned single judge that if the appellant would fail to comply with the order, then the interim relief granted to the appellant shall be treated to have been withdrawn. The certificate officer Shekhpura was further directed to decide the case within a period of 3 months from the date of deposit of the aforesaid amount by the petitioner. It is the case of the appellant that because of illness he could not deposit 15% of the certificate amount within the stipulated period and chose to challenge the aforesaid order only in the year 2021. Considering such delay in the matter, we are not inclined to entertain this appeal. The appellant would be well advised to approach the appropriate authority for the needful. Since we do not find any fault with the order passed by the learned single judge, we find no justification for interfering with the same. The appeal is dismissed, but without any order as to costs.
Serial 10, Mr. Asutosh Singh.
May it please your lordship. The short
No,
issue.
what is this office notes? Self-contradictory.
My lord, I am appearing for the
self-contradictory. लिखिए. The office objection does not appear to be justified as against the order passed by the commercial court. An appeal under section 13 of the Commercial Courts Act 2015 has been filed. The defect pointed out therefore is ignored. Yes.
Lord, the short issue is as to whether the commercial court was competent to try this suit, because the application under Order 7 Rule 10 of CPC has also been rejected. Our case is that Memorandum of Understanding for Development of Land is not a commercial dispute.
Who says so?
Not section
Commercial Courts Act दीजिए.
2C7.
I think it's in the beginning of the schedule.
2C7 खाली देख लिया जाए. बस उतना ही.
We find that you have filed some application under Order 6 and Order 7 both. For striking off and for
दूसरा वाला जो है 2C7.
If that is your only ground, then you are on a weak footing, Mr. Shahi.
My lord, I am appearing for the respondent, my lord.
Unless we call upon you, what is the necessity of your just sit and watch. Take your seat and watch the proceedings. In case we are allowing his petition, then only you get up.
Section 2C7. Agreements relating to immovable property used exclusively in trade or commerce.
And trade and commerce is building and commercial building and all that. It's an interesting song, Mr. Salesh Kumar Singh. So agreements relating to immovable property, the property is immovable, used exclusively in trade and commerce.
So अभी तो बना ही नहीं है तो use.
It has to be decided in a summary manner according to the commercial courts. We don't. Unless you show us from law
There is a judgment, but that also deals with development of land. But
I think that's the judgment. It comes under one of the categories of commercial cases.
because if it was for development of land, commercial user or exclusive commercial user, whether it is residential user, multi-story building for
that restrictive interpretation would defeat the very purpose of the act, Mr. Shahi.
memorandum of understanding है आपके पास?
Was that suit, title suit number 510 of 2016 withdrawn?
by the other side. Yes.
That has been withdrawn. I heard Mr. P.N. Shahi, learned senior advocate for the appellant, and Mr.
Jitendra Kumar.
And Mr. Jitendra Kumar for respond number 1. This appeal has been filed against the order passed by the learned additional district judge number 7 Patna, special commercial court in commercial case number 3 of 2017, whereby the application made on behalf of the appellant slash respondent before the court below, whereby two of the applications preferred under order 6 and order 7, preferred under order 6, preferred under order 6 rule 15a bracket 4 and 5 of CPC and order 7 rule 10 of the CPC respectively have been rejected. Mr. Shahi, learned counsel for the appellant
Defendant
has assailed the aforesaid orders on the ground that the dispute between the parties would not come within the category of commercial dispute, as there is nothing on record to indicate that the dispute between the parties was with respect to agreement relating to immovable property used conclusively in trade and commerce. Stop. The learned counsel for the learned counsel for the respondent, the learned counsel for the respondent, no, the learned counsel for the respondent has submitted that Learned counsel for the respondent bracket plaintiff has submitted that he was the assignee of the housing project under the name and style of Ram Gola City project to be built and constructed under the registered development agreement dated 28/9/2013 between the appellant defendant number 1 and the landowner. On the asking of the respondent, on the asking of the appellant respondent, the plaintiff appellant had agreed to fund and finance the project and entered into an agreement to take 50% of the built-up area and be a part of the board and be a director of the director in the board of directors of the defendant company with share up to 30% of the share capital. During the prosecution of the case, two of the applications as referred to above were filed. One for striking off the averments made in the plaint for the same not having been verified by the deponent as mandated under Order 6 Rule 15A 4 and 5. First up, the commercial court, on finding that similar application was rejected twice, refused to entertain the aforesaid application, holding it to be a repetitive attempt to avoid the case being tried summarily as mandated under the Commercial Courts Act 2015. The application under Order 7 Rule 10 was contested by the plaintiff respondent, by the respondent plaintiff, on the ground that the issue involves the commercial use of the land in question, thereby bringing it within the commercial dispute as defined under Section 2(1)(7), which includes agreements relating to immovable property used exclusively in trade or commerce. Mr. Shahi, learned counsel for the appellant defendant, has raised the objection that the commercial court ought to have found out whether such agreement was with respect to immovable property which was to be used exclusively in trade or commerce. First up, the land was assigned by the landowner for construction of a multi-storied building, which made it an agreement relating to immovable property used exclusively in trade or commerce. First up, the contention of the appellant defendant therefore is not sustainable in the eyes of law. We do not find any fault with the order passed by the commercial court rejecting both the applications of the appellant defendant under Order 6 and Order 7 of the CPC. First up, there is no merit in this appeal. The appeal is dismissed.
For orders on petition, Serial 11, Mr. K.M. Joseph.
Kindly pass over for a day.
Sorry.
The senior counsel is out of station.
this evening he is reaching back.
These are few matters which we do not normally pass over. You can seek a passover, but what is there in the case? Try and assist the court. Let us see. You represent the school, St. Xavier's School.
St. Xavier's School, yes. I got the brief only this morning. I am not sure of that.
Let us read together.
Okay.
What is the matter?
This is an application challenging the order dated 22/1/2019, passed in CWJC.
You sound like Mr. Joseph.
No, I am not.
You're not Joseph.
No, I am not.
But you sound like him. Are you from his family?
No.
What's your name?
I am Sebin.
Huh?
Sebin.
Sebin.
Sebin, yes, yes.
All right. So the court has, the Lund single judge has made scathing remarks about the school principal, right?
Yes.
So therefore you are aggrieved. Otherwise there is nothing in the order which should bring you here in appeal. Right?
Yeah, that's right.
Now come to paragraph 21, 22. Better 22. Your decision has not been interfered with, right?
Yeah, that's right.
And there is no positive statement of the Lund single judge against the principal, because he says that it is difficult for me to decide on the set of facts before the court. So therefore, what gives you the occasion to prefer this appeal? The student has lost his academic year. You have not taken his admission. You have not been asked to take his admission. The court has only asked the principal secretary of the education department to ensure discipline even in private minority institutions in view of, I don't know, standard minimum rules or of administration of juvenile and so and so and so forth. The report had to be given by the principal secretary of the education department. So if any person who was aggrieved by this order was the state and not you, think about it, come back to us tomorrow. We give you time to, now read paragraph 22 with the court.
What has been done by the school administration now, with the delay caused by the parents of the student, cannot be undone by this court, because no direction can now be issued for reinstating the student in the school.
Right, that's right, just stop here. So therefore the student who was rusticated, who was thrown out of the school, he has not been admitted. No direction. Nearly 8 months after he was removed, as the writ application itself was filed. So this is no direction to you. Then read para 23. Now why should you have filed this appeal? And this is what you need to tell before this court. Now read para 23.
However, in the background of the fact that there is a report of the committee constituted by the district magistrate, Patna, which does not justify the action of the school management, I have considered it appropriate to issue certain directions to the
state government and not to the St. Xavier's School or the principal. Alright?
That's right.
Now what is that? For effective implementation of the provision under section 18 of the Act. Which Act? Section 18 of which Act? 18 of the Bihar Non-Government Secondary School Takeover of Control and Management Act 1981. So where are you in the picture? Who are you?
I am for the state. For the state, Your Lordship.
आप क्या किया है? What has the principal secretary done about this order? It is not against St. Xavier's School or the principal.
My Lord.
I don't know why he has preferred an appeal. You were supposed to find out. Now, Mr. Counsel, what is your name?
Prabhat Ranjan Singh.
You are in the office of which government council?
AG5, Your Lordship.
Huh?
AG,
Who is AG5?
Mr. Sarvesh Kumar Singh.
Where is he? ना
I
दोनों
call.
साइड आप लोग फाइल नहीं पढ़ के आते हैं, बड़ा मुश्किल है. Now read para 24, that's for you.
Accordingly, I direct the Principal Secretary, Education Department, Government of Bihar to ensure issuance of exhaustive guidelines to be followed strictly by the minority institutions without interfering with the regard with rights of minority institutions to establish and manage an agency under Article 29 and 30 the Constitution of India. In view of the report of the 4 members committee, let the decision be taken by the state government whether action as completed under section 18 of the Act against the school is desirable or not. This must be done within 6 months from the date of passing of the project.
Now 6 months have passed, right? 7/5/2018 is the date of the order. It was uploaded on 28/1/2019. Now we take it from 28/1/2019. We are in mid of 2022. What has the Principal Secretary done?
I have to seek instruction.
What instructions will you seek? You have not even read this paragraph of the order, and you have come to defend. You have come to defend this appeal. Ask Mr. Sarvesh Kumar Singh to appear before the court rises. That's not done. And you, Mr., since you have got the brief today only, think whether you have, whether you have unnecessarily preferred this appeal. We will record that this appeal was not required to be filed. There is no order against you. ऐसे ही फाइल कर दिया आपने अपील. Not even for academic purposes. You are just required to read one part of the order, one paragraph of the order. Where is Mr. Joseph?
He's out in Ranchi.
He is?
He has gone to Ranchi.
Now seek instructions from him on telephone whether you would still like to pursue this appeal, or should we pass an order saying that it was misconceived to prefer this appeal. There is nothing against you. You have thrown the student out of the school, you have not admitted, the court has not given you any direction, court has given direction to the state. And that doesn't concern you in particular, that concerns all educational institutions. Where is the question of appeal? So why should we not saddle you with cost of rupees 50,000 to be deposited in some society building exercise for having wasted the time of the court? Now you don't argue on the order, on the justification of the order, you argue on the justification of preferring this appeal and why you should not be imposed cost upon. Okay?
I'll come back.
Pass over. And you tell Mr. Sarvesh Kumar Singh to appear tomorrow.
Well.
C12, Mr. Salesh Kumar.
In this case, I pray for 2 weeks time.
We reject your prayer because you don't put your mobile on airplane mode or vibrator mode while sitting in court.
I was extremely sorry.
So therefore your prayer is rejected for Passover.
My lord, I have switched, but since the wrong bottom has been a lordship, shifted down a lordship, therefore it could be ranked a lordship. I am extremely sorry for that, my lord.
So we are not doing anything, we are only rejecting your prayer for Passover. You argue the case.
My lord, since your lordship, today it is order on petition. I have a lordship not prepared on merit, a lordship. First time it has come, my lord.
It's a 4 pages order.
My lord.
You could have read that in 4 minutes.
A lordship, but since one senior counsel have to assist, a lordship, therefore a lordship.
Who is the senior counsel?
A lordship, my instruction is there. However, I don't know my.
Who is the senior counsel who is to address the court?
I am not knowing a lordship.
You don't know?
No, since
then
my
how can you make this statement?
my instruction is there, a lordship, since first time it case.
Are you so much controlled by your client that he will not
no,
tell
my
you the
lord,
name of the advocate?
I am not, my lord, but since a lordship today first time come a lordship, I am
prayer refused.
Then I myself will argue lordship, but I require some time, my lord.
why should we take notice of this appeal? Now, you have the file with you?
My lord.
You have drafted the appeal?
My lord.
Right. Now, come to internal page 2 of the order. पर क्या ये साहब आपको contempt court ने कहा
My lord.
कि go before the authority. You did not go before the authority. Even the contempt was misconceived. There is a provision under section 64 for you to agitate. That you have not done. You have not even followed the orders passed by the court in contempt jurisdiction. You don't do anything, and after 10 years you say that my compensation is less.
Petitioner went to the appropriate authority, lordship, but
पढ़ के आइए.
my lord.
We don't find anything in this.
Next week, my lord.
Next week, नहीं tomorrow.
I will in difficulty.
No, sorry. Then we decided today. Take time, read, and come back to us. Why should we keep all these unnecessary, frivolous appeals pending?
At least a lordship on Friday, my lord. Friday तो virtual हो जाएगा, फिर Monday तक कर दिया जाएगा.
As prayed on behalf of the appellant, re-notify on दे दीजिए Monday का date.
Obligement.
4th of July. For admission serial 13, Mr. Arun Kumar.
The present appeal is directed against the order passed by Honorable Single Judge, under which, my lords, without taking into consideration the annexure 1, page 18 of the REIT application, which is the government resolution, my lords, with regard to granting affiliation to any madrasa, my lords. The petitioner appellant is the, my lords, head Maulvi of a, my lords, madrasa.
Of a different madrasa.
My lords, I am just only factual aspects के चलते हुजूर ऐसा ऑर्डर पास हो गया. हम लिखे हुए हैं कि हमको ग्रामीणों के द्वारा एक स्कूल या मदरसा है जो कि इस्टेब्लिश किया गया, हम उसके हेड टीचर हैं, हमको ग्रामीणों के द्वारा पैसा जो भी होता है मीगर अमाउंट दिया जाता है, और एक ग्रामीण ने 2 कट्ठा जमीन हमारे इस इंस्टीट्यूशन को लिखा था जिस पर
कहाँ डिस्प्यूट है?
हुजूर जस्ट आ रहे हैं हुजूर, बिल्डिंग बना हम चला रहे हैं. प्राइवेट रिस्पोंडेंट हैज डन, my lords, this showing the building of my madrasa, which is contrary to guidelines, because resolution says that within the periphery of 4 kilometers, if another recognized madrasa is situated, then within that periphery of 4 kilometers, no other madrasa.
से मतलब नहीं है वकील साहब, Mr. Arun Kumar. There are two things. If you say that your building has been shown by the respondent number 8 and recognition has been obtained, then you had a case. Just a minute. If you will say that the recognition to respondent number 8 was granted, dehodes the rules, then the single judge has fined you for 20,000, we will fine you 40,000. Where is the statement in the writ petition that the building constructed by the villagers, 2-room building, was used by respondent number 8 to get recognition of the madrasa? Show me that, we will issue notice. Otherwise, we increase the cost of 20,000 to 40,000.
Just
and the single judge was right when
paragraph 7
of the writ
application. May I have a look, my lord. That is relevant to mention hereby. Para 7 page.
Para 7.
Ji,
just a minute.
That is relevant to mention here that in year 2011, the secretary cum head Maulvi of respondent number 8, that is Madrasa so and so, managed to fraudulently get the same 2 kattha of land already registered in favor of.
These are two different things. Now show you. Let us see the sale deed by which you had acquired the same 2 katthas of land. Where is that?
I have got, but because I had not brought on the.
आपकी अपील क्या है? इसी बात की अपील है ना कि आपकी जमीन उसने दिखा दी अपने नाम पे.
उसको दिखा दिया. हमने कहा था हुजूर ही कि 2 कट्ठा जमीन
आप दिखाइए. ये सब मिस्टर अरुण कुमार जो आपका क्लाइंट कहेगा वही आप हमें कहेंगे, ऐसा नहीं होगा. डॉक्यूमेंट दिखाइए.
क्योंकि हम
डॉक्यूमेंट दिखाइए और ये बताइए उसके रिकॉग्निशन से कि उसने ये जमीन यही जमीन दिखाई है. ये कैसे पता चलेगा?
अब हुजूर इसके लिए हमने एनेक्चर 3 रिप्रेजेंटेशन मेरा था हुजूर
कहाँ था
ऑफ द रीट एप्लीकेशन में काइंडली
कहाँ देखें
जी हुजूर एनेक्चर 3 पेज 22 ऑफ माय रीट एप्लीकेशन मिलर्स
पेज
22 of my writ application. Petitioner has represented before the chairman of the Bihar Raj Madrasa Board and copy of the same has been sent to all others.
वो सब बात छोड़िए ना, इसमें कंटेंट्स दिखाइए, कंटेंट पर असर होगा
जी। निवेदन है कि ग्राम स्वयं और उनके स्थापना छात्र छात्राओं को पढ़ाई लिखाई हेतु ग्रामीणों के सहयोग से हुई, जिसके लिए बीबी शाहजहां जौजे स्वयं मधुबनी ने अपनी इसी गांव की हकीकी जमीन खाता नंबर स्वयं मिलजुला 4 कट्ठा और 2 धूर के जानी पूरब से 2 कट्ठा निबंधित दस्तावेज संख्या स्वयं दिनांक 25/1/2007 ईस्वी को वक्फनामा लिख दिया, जिस पर ग्रामीणों के सहयोग से 12 फीट इंटू 15 फीट का 2 कमरा पूरब रूप का पक्का ईंट एवं एस्बेस्टस का मदरसा का भवन बना, जिसमें गांव के छात्र छात्राएं पठन पाठन करते आ रहे हैं। छात्र छात्राओं को पेयजल हेतु तत्कालिक मुखिया स्वयं के द्वारा चापाकल करवा चुके हैं।
मोहम्मद शोएब और बीबी शाहजहां में क्या संबंध है?
बीबी शाह उनके परिवार के कोई हैं। जब बीबी शाहजहां ऑलरेडी पहले रजिस्ट्रेशन कर चुकी थी तो उनके परिवार
ये तो आपने बीबी शाहजहां का वक्फनामा
जी जी हम तो वही कर रहे हैं।
आप अपना वक्फनामा दिखाइए जो शोएब ने आपको किया है। ये सब इधर उधर मत करिए मिस्टर अरुण कुमार। आपका वक्फनामा कहाँ है? ये शाहजहां बीबी का है।
हाँ, बीबी शाहजहां
जिसने नंबर 8 को दे दिया है जमीन।
वो मेरे पास नहीं है।
अरे ये तो आपने यही दिया है, नंबर 8 की जमीन ये है।
हमने ये कहा हुजूर जो हमको जानकारी है उसका नहीं है। हमने रिप्रेजेंट किया था कि इसके कंटेक्स्ट में इसको आप इंक्वायरी कर लीजिए कि दोनों चीज है। तो हमारा
आप इंक्वायरी हम करेंगे जब प्राइमा फेसाई आप सेटिस्फाई करेंगे लर्नेड सिंगल जज को या डिवीजन बेंच को, तभी तो
जी
आप हमें ये दिखाएं कि आपको 2 कट्ठा जमीन मोहम्मद शोएब ने हम दान कर दिया।
बीबी शाहजहां
आपको बीबी शाहजहां
जी जी
तो शोएब वाला ऑर्डर दिखाएं।
इसी उसका वाला
आपने उल्टा लिखा है
जी। हम रिप्रेजेंटेशन में यही लिखा
आपने लिखा है कि अपनी इसी गांव की हकीकी जमीन
जी बीबी शाहजहां
मोहम्मद शोएब ने वक्फनामा लिख दिया, जिस पर ग्रामीणों के सहयोग से। आप तो पता नहीं आप क्या लिख रहे हैं, क्या पढ़ रहे हैं। शोएब ने आपको लिखा है, शाहजहां ने 8 को लिखा है। उल्टा बोल रहे हैं आप। साहब आप कैसे मौलवी हैं, दूसरे मदरसा बंद कराना चाह रहे हैं?
नहीं, हम बंद नहीं करना चाह रहे थे। हम तो इतने ही खाली चाह रहे थे कि जो
आपसे जो पूछते हैं उसका जवाब दीजिए। ये सब जो काउंटर सप्लीमेंट्री क्वेश्चन है उसको सुनकर इग्नोर करिए। आप केवल हमें दोनों सेल डीड दिखाइए, दोनों वक्फनामा दिखाइए, तब मुझे समझ में आएगा। अगर वही लैंड नहीं है, तो मिस्टर अरुण कुमार, योर क्लाइंट वुड बी नेक डीप डिफिकल्टी। वी आर गोइंग टू रेज द कॉस्ट टू 40,000। तो आप हमें दिखाएं, मैं कहां मना कर रहा हूं। सिंगल जज ने आपको सुना नहीं, ऑर्डर पास कर दिया। डिवीजन बेंच आपको सुनना चाह रहा है,
वहां पर यही
आप हमें दिखाइए।
हम दिखा रहे हैं हुजूर को। मोहम्मद साबिर
देखिए ये जो जमीन है ये
है उर्दू में है, हिंदी में।
बीबी शाहजहां ने मोहम्मद सुहेल जौजे मोहम्मद सुहेल को दिया
है
मदरसा अरबिया हिदायतुल उलूम। ये मदरसा हिदायतुल्लाह भी है। मदरसा अरबिया हिदायतुल उलूम। ये डॉक्यूमेंट से तो बीबी शाहजहां का ये है। ये किसका है?
वो भी मिल गया, मोहम्मद साबिर, यही है।
आपने
हमारा शाहजहां का है और साबिर ने देख लिया। शोएब
ने वो
साबिर अब नाम
वही जमीन है। ये कैसे पता चलेगा?
अब तो हुजूर खाता खसरा का कुछ पार्ट इसका है और उसमें से क्या किया कि क्या
आप एक एफिडेविट दीजिए कि जो जमीन आपको वक्फनामा की गई थी
जी
वो नंबर 8 ने अपने नाम पे दिखा के रिकॉग्निशन लिया, मदरसा बन गया।
स्पेसिफिक हम
ये कल एफिडेविट दीजिए।
अब कल तो हुजूर आएगा।
Then we might consider. Yes, Mr. Madrasa Board.
Yes, Lord. My submission would be, Lord, the single judge honorable sentencing order is rightly. So far as, Lord, his
That's right. But if
his prayer is concerned, Lord,
no,
in the writ court.
Mr. Aslam,
yes.
kindly understand what the court is thinking. Now, he may not have argued there before the single judge. He may not have annexed the documents. But if he is able to demonstrate, if he says that the document which, if he says that the land was earlier given to him by Waqfnama, by a competent vendor, by a competent donor, then that land could not have been shown by respondent number 8 to have been given to him. Yes. Okay? If that is the case, then the fight is not, then the filing of the writ petition was not frivolous. Or for that matter, the appeal is not frivolous. Yes. But somehow the other, Mr. Arun Kumar has been able to communicate that the recognition to the madrasa run by respondent number 8, that recognition should not have been granted because there are two institutions, two such madrasas yes. within the periphery of 4 kilometers. He is no one to question that. Now, if he says that his land has been used wrongly, then perhaps he has a case. Give an affidavit. Annexing both the documents.
Person will come from Madhubani.
Apart from that, Lordship, admittedly there is a dispute with respect to the managing committee, Lord. There is a judgment of the Supreme Court. Such private committee, the Honorable Court in jurisdiction can be decided, Lords.
Milord, I am disputing the submission made by my learned brother.
That judgment has no application here.
Petitioner madrasa.
Since there is a
that has
dispute
got no
only with respect to two committees, that one committee run by another madrasa, his committee.
That dispute will come later. Now we are only questioning his bona fides in preferring the writ petition and the appeal.
Then I will examine, Lord, sir.
You examine and let him come with an affidavit.
Yes.
Affidavit to be sworn by the appellant himself. If we find that his statement is wrong, we'll send him to jail.
Yes.
Milord, return back me both the so that I may.
Mr. Arun Kumar, learned advocate, has been directed by this court to file an affidavit sworn by the appellant that the land over which the madrasa of the appellant is situated has been shown by respondent number 8 for obtaining the recognition for madrasa. Let that be done by the next week. Re-notify on Tuesday का date लगा दें.
5th of July.
वो दोनों deed दे देना.
Seal 14, Mr. Ramnandan Kumar Sinha.
Yes, Mr. Sharma.
In this case, my lord, as per your lordship order निकालो ना. In which the point was formulated. Yeah. Page below, dated 29/3/22. नहीं ये वाला नहीं, इसके पहले वाला.
इसके पहले.
बड़ा वाला ऑर्डर जो है.
28.
एफिडेविट फाइल किया इन्होंने. आपने सरकार ने एफिडेविट फाइल किया.
My lord, I am for the holding company, my lord.
नहीं आपसे मतलब.
We have the state power holding.
गवर्नमेंट की तरफ से कौन है?
Affidavit was filed, my lord, on 4/5/22, my lord.
इनको दिया है कॉपी?
ये कॉपी मिला.
4/5. क्या लिखा है?
In this case, Lord, they say that.
क्या कहा इन्होंने?
Appointments of my lord the inspector was made. अभी वाला जो है, अभी जो दिया है, अभी जो नया वाला, वो जो लोग दिया है तो
नहीं तो आपने रूल बना दी, अपॉइंट किया.
वही ना कहा ना
वही तो हमने वही तो लिखा है इस ऑर्डर में.
Para 5, my lord, kindly see, my lord, para 5 of the said counter, my lord. Para 5, page 3, my lord. That is submitted at exercise of power confirmed by section 1 of
इंस्पेक्टर्स तो आपने बहाल कर दिया,
my lord.
आपने चेयरमैन मेंबर्स ऑफ द बोर्ड बहाल किया, इंस्पेक्टर डिसाइड करेगा ये
इंस्पेक्शन किया, क्या रिपोर्ट दिया नहीं दिया कुछ बताएंगे।
लेबर सुपरिटेंडेंट।
अरे आप उसी चीज को क्यों पढ़ रहे हैं, मैंने देख लिया। आप who you are in the office of which standing council?
Learned age is given, my lord.
कौन है वो?
Mr. योगेंद्र प्रसाद सिन्हा।
बुलाइए।
He is in chief court, my lord.
चीफ कोर्ट तो मैं क्या करूँ, आप तैयार नहीं है।
My lord, my lord.
मैं इसको पास ओवर कर रहा हूँ। Ask him to Mr. Sharma come back to us tomorrow.
उसको परसों रख दिया।
देखिए।
पर्सनली कुछ बात है।
परसों फ्राइडे मंडे जो कहें वो रख दे।
परसों रख दिया कोई।
देखिए, let this case be listed for further consideration on day after tomorrow date.
30th of
Ask
June.
Mr. Yogendra Sinha to appear. You will only repeat what you have stated in the counter affidavit. Inspector appointment we are not questioning.
No, my lord.
Now the matter was to be decided by the board. The board has yet not been constituted. You are talking since 10 years, and therefore you are not paying to these persons. Or take a decision that they shall not be treated equally. We will see that. We will, Mr. Sharma will question that decision.
Your lordship, the order has to be seen, and in that everything is given. Earlier order, your lordship has formulated a point.
उसी को देखकर हमने ये सवाल। Day after tomorrow.
Seal 50, Mr. Mohammad Musawir.
My lord, kindly pass the photo, my lord.
क्यों मोहम्मद मुसव्विर?
फर्स्ट टाइम आया हुआ है हजूर।
फर्स्ट टाइम क्या मतलब होता है? 2019 का ऑर्डर है, 19 में आपने अपील फाइल कर दी और 22 में हमारे पास आया, आप कहते हैं फर्स्ट टाइम आया है। कल कर देख कर आइएगा। 45B की एप्लीकेशन फाइल किया था क्या आपने?
जी, एनेक्स 2 जो है
नहीं किया था, और 45B अब डिलीट हो गया 45D के तहत, तो आपने किया ही नहीं। 28 साल के बाद, 30 साल के बाद आपकी तंद्रा टूटी है, क्या करेंगे अपील में? 45B में अगर आपके पिताजी ने एप्लीकेशन फाइल किया होगा मिस्टर सुल्तान, तो उसकी स्टेटमेंट आप दें या उसकी बताएं उसमें क्या हुआ। अदरवाइज ऑल्सो इट विल अबेट। ठीक है ना भाई, यही ना है 45D, यही है, हो गया ही नहीं है। क्या करेंगे आप? ये डिसमिसल ऑर्डर लेंगे कल भी, आइए आप तैयार।
Seal 16, Mr. Mukesh Kumar.
My lord. This is order 22, may I see, my lord? 22/20, my lord. Directed to the You should act to the
just one. You represent respondent number 6, Mr.
No, my lord, for the university, your lordship.
And respondent number 6 is whom? State of Bihar.
My lord.
Now the state of Bihar has to release funds, no? And look at the attitude. You are representing the state. Now an award has been passed which has not been challenged. The learned single judge may have rejected the petition, but the coordinate division bench which was hearing this appeal. Are you aware of the order? Before us, it is stated that the award passed by the tribunal in favor of the appellant has attained finality. The respondent university institution has not challenged the same. If that was so, then a model employer, we see no reason. Now, what do you have to say, Mr. University?
My lord, I may be permitted to seek at least instruction and
What
see.
instruction will you seek? Look at
My lord, with regard to the payment of
counter
wages.
affidavit of the state. He says that he would have better gone before the authority, would have filed complaint case under 28, but we shall not pay to him. Now this is what the litigation policy of the state of Bihar. We are going to come down heavily.
We see that from the last.
The only difficulty is that he waited for 10 years to vindicate his claim. Nonetheless, we will not, since the award has not been challenged, we will direct you to pay.
Well, I may be permitted to seek instruction and make a submission in the next state, my lord. Will ensure.
Have you followed what has happened?
My lord.
Unless you follow the issue, perhaps instructions would not be forthcoming.
My lord.
Now, this man was removed from service.
My lord.
The issue was decided as a labor dispute and the matter was referred to the board. The labor court decided that no, his ouster was bad and directed for his reinstatement with full back wages. He has been reinstated in service since 1997 but has not been paid his back wages. The state has filed the counter affidavit, you have not. The state says that he should have preferred a complaint against the hearing officers. Is that the answer?
My lord, I am only saying with regard to payment of wages and the reason behind non-payment, I will seek a specific instruction. That is what I am saying, my lord.
Payment of the back wages.
My lord, absolutely.
So therefore, can you defy the order of the labor court? The state government will not be at fault. Where have you written to the state government for releasing fund for payment of back wages? You have not done anything. You have not even responded to this petition. Who appears for the university? You must be junior to somebody.
My lord.
Who appears for the
Mr.
university?
Mustafa appears, Ashar Mustafa.
Where is Mr. Mustafa?
He is in a coordinate bench, my lord, in an ongoing matter, your lordship.
Then we call the vice chancellor to ask him.
My lord, and he'll appear in 10
The
15
lawyer
minutes.
will not come.
Well, may kindly come up 15 minutes, then he'll be here. Because matter will get over in the coordinate bench, your lordship.
All right, we are adjourning the matter. Ask him to be here tomorrow.
My lord. Serial 17, Mr.
And Mr. State, whoever has shown the affidavit on behalf of the state, we are going to ask questions from him or her, whoever she is. That is not the way a litigation is. That's not your litigation policy. आपने लिखा है कि वो उनको जाना चाहिए, केस फाइल करना चाहिए, हम पढ़ता हम देखेंगे. बढ़िया है. कौन है आपके सीनियर?
Mr. Sarvesh Kumar Singh.
So they have chosen not to appear before this court.
There is another court.
आप कहिएगा रहेंगे यहाँ.
Serial 17, Mr. Manendra Kumar Sinha.
Lordship, due to some personal difficulty and some compelling circumstances, I want 2 weeks time, Lord.
You are Mr. Manendra Kumar Sinha?
Yes, sir, my Lord.
क्या क्यों 2 weeks चाहिए?
My Lord, I have shifted my office in another place, so
आपके पास फाइल नहीं है.
फाइल इधर उधर हो गया है, जो कि सैटरडे संडे को खोजेंगे पूरा. उसमें अचानक ही केस चढ़ गया.
परसों खोजेंगे आप.
अचानक केस चढ़ गया, हड़बड़ में मिल नहीं पाया, तो हमको 2 दिन कम से कम समय चाहिए. नेक्स्ट वीक में रख लिया जाए तो.
Mr. Manendra Kumar Sinha, learned counsel for the appellant, submits that because of the shifting of his office, the file has been misplaced. He submits that he shall arrange for the file and shall address the court on the next occasion. Re-notify on Tuesday.
5th of July.
5th July.
5th July. Serial 18, Mr. Srinivas Madhuvan.
Pray for 2 weeks time, Lord, because I has been misplaced, Lord. नहीं हुजूर, हम हमारा पहले से ही था, हम ऑफिस नहीं शिफ्ट किए हैं, लेकिन हुजूर फाइल मिसप्लेस है. हम सुबह में हुजूर मेंशन किए थे, लेकिन हुजूर कहा गया था कि when it call out.
आपको मैं अपनी फाइल दे रहा हूँ, आप आज पढ़ लें, अभी पढ़ के नोट बना लें, कल बहस करेंगे. Tomorrow.
1 सप्ताह कम से कम हुजूर दे दिया.
That's not done. आपको कुछ पता ही नहीं होगा, कुछ सवाल भी नहीं पूछ सकेंगे हम आपसे. कुछ पता है इस केस के बारे में?
पता है हुजूर, लेकिन अब 3-4 साल हो गया है हुजूर।
तो आप religious trust board, who appears for the religious trust board? Mr. Ganpati Trivedi perhaps is the advocate.
Yes, my lord.
You inform him, come tomorrow. Go through the
It
file.
may be on next week, my lord.
इनको फाइल अवेलेबल कर दीजिएगा, पढ़ेंगे अभी।
Senate Mr. Kumar Kaushik.
May it please your lordship.
Yes. Netaji Subhas Institute of Technology, Amhara, is it a recognized institution?
My lord, it is
Affiliated
recognized.
to Aryabhatta Knowledge University.
My lord.
Now, how do we know that you were teaching there? Any record maintained by the university?
My lord, that has come, in fact, this is the stand in the counter affidavit that there is no record with the university with respect
Then
to
how
the-
would a registrar countersign your experience certificate?
My lord.
That way he would be facing a criminal prosecution, Mr. Kaushik.
My lord, if at all the appointment of the petitioner was not made by the competent authority.
Then perhaps, Mr. Kaushik, you're right. Then you have a list against the university.
My
Then
lord.
you have a list against the university. Now, where have you placed before the learned single judge the documents in your possession which would justify your grievance against the registrar in not countersigning your certificate?
My lord, the advertisement by way of which the petitioner was appointed.
Where is that?
Is at page number 9 with the rejoinder filed in the writ petition.
Have we issued notice to the principal of Netaji Subhas, of the institute as also of the Aryabhatta Knowledge University? You are for whom?
The state law.
No, state. Who appears for Aryabhatta University? क्या है इनका कोई रिकॉर्ड नहीं है?
My lord, my submission
The
is that
has the principal certified that you were there?
in fact the principal has, the Netaji Subhas Institute of Technology has issued an experience certificate. It was required to be countersigned by the registrar.
No, that's right. We have told you this.
So
the registrar refuses to countersign because he says that there is nothing on record. There is no record in the university of your appointment.
there are two documents, if I may show.
Yes.
In the reply, my lord will find
Reply to what? Writ or LPA?
the reply to the writ petition.
Counter affidavit of?
There is only one rejoinder counter affidavit filed on behalf of 4, 5 and 6. This is the response by the petitioner in which list of faculties for AICT approved institutions as on 30/4/2015 is enclosed.
Where is that?
At page number 10. And this has been downloaded from the site
This is walk-in interview of what?
This is, my lord, this is the advertisement by way of which the petitioner was appointed. And the next page is downloaded from the website of the AICT. List of faculties for AICT approved institutions. Annual year 2015-16 as on 30th April 2015. And my lord will find
Your name falls where?
It is at serial number 201-2048 at page number 12 of the rejoinder.
2048.
Page number 13, 2048. And apart from this, my lord will see, if my lord will see the counter affidavit filed on behalf of the university.
नहीं, that you joined and that you were rendering your services as a teacher, ये कैसे इससे पता चलेगा? That you were inducted.
It is the list of
That you were
faculty.
inducted. Now, whether you, because you must not, all these faculties would not be paid in Netaji Subhas Institute. That's a self-financed institute. There is only recognition.
My lord, if the,
Sorry, affiliation. no medical, no financial assistance.
But if the institute
Now
is...
you show to us that you have been paid for the services rendered by you for all these years.
But
How many students have passed, whether you have taught, whether there is a record of the school. This is the, we will ask R.A. Bhatt University why they are not keeping the records of their affiliated college. But you need to show us in the first instance, for us to interfere with the order of the single judge, that right after 2015, when you were inducted in the walk-in interview in an institute which has been given affiliation by AICTE, you joined the services and you are rendering your services. Right? Suppose somebody comes, I mean, I did not explain it to you, you are a good counsel. Suppose some law intern now comes and meets me and says that I want to intern in your court, and I say yes, but he doesn't file any application, does not pursue, and he is not granted permission, and doesn't, and there is no record of this court that he has been attending. Now, can this court give a certificate that he has had experience in this court? No.
No.
No. So therefore you appeared in walk-in interview, you were selected. If we accept this page 112 to be correct, then we give it that you were successful in the walk-in interview. Whether you joined that job, whether you continued teaching, whether you were being paid or whatever, your services were being recognized. Where is the appointment letter?
My lord. Appointment letter is Annexure 2 with the writ petition. Annexure 1. It is at, I'm sorry, my lord, it is Annexure 3 at page number 20. This is the letter of appointment.
Page 20.
Page 20. On 2/5/2014.
The board has recommended for your appointment. You are requested to sign on the second copy confirming your acceptance.
My lord, this is consequent upon your interview with us.
No, that's right.
We take pleasure of informing
you. So we agree that you joined. We agree that you joined.
And
now, where is the annual statement of the college which is sent to the university for them to keep a record? I mean, there has to be something, no?
My lord, in fact, there is one letter brought on record by way of counter affidavit at page number 18. The university itself has designated me, appointed me as co-examiner for the course code so and so. That is at page number 18.
Of the counter affidavit?
Of the counter affidavit. This is issued by the university on 14/2/2016.
And this is somewhere in 2016. Yes, Mr. Yes. If you did not have any record of the faculty of that Netaji Subhas Institute, how have you acknowledged him and how have you made him the co-examiner? Look at page 18, running page 69 of the brief. तो ये पहले दिखाते मिस्टर कौशिक कितना क्वेश्चन क्यों पूछवाया आपसे?
I'm sorry. My lord, what has happened?
Did you state this before the single judge?
It is part of the record before the record.
That's not right. Part of record is everything. You must place it before the single judge. Single judge says that there is nothing on record.
I am not aware whether it was placed or not.
You are not the lawyer.
Mine.
All right. So this is a document by you. This is a document which has been signed by you. Therefore, when you say that there is no record, you are obviously lying.
Not a single record in university or lordship.
So how have you made him co-examiner? Not a single record. Can you say that? आप नाम से इनको बनाया है?
नहीं.
ये forged letter है?
No, your lordship. No.
तो आपने जब सिंगल जज लिख रहे थे, डिसाइड कर रहे थे पिटीशन, तो आपने ये डॉक्यूमेंट क्यों नहीं दिखाया? हाउ डू वी नो? We are not going to remit you, send you to the single judge, we will decide it here. But you tell us, it should have been shown.
In fact, my lord, if I may submit, they are not counter-signing the experience certificate even with respect to teachers appointed by Department of Science and Technology in the teachers maintained by the department, in the colleges maintained by the department.
Why?
As a matter of rule, there also they have stated that we have no records, and those colleges are maintained by the government of Bihar.
You close down your university. Send the entire records to the earlier university which was handling all this. You don't have the record of any institution, and you keep appointing them as co-examiners. Who is your Vice Chancellor?
Vice Chancellor SP Singh, Your Lordship.
You would like to hear from him. What
In
kind
charge
of
Vice Chancellor. In charge Vice Chancellor, Your Lordship.
No, we are surprised. Now we could have accepted your contention that there is no record. Netaji Subhash Chandra Institute, Amhara, it may not be existing, but you have made him, way back in the year 2016, you have made him a co-examiner in Chanakya National Law University campus. So record nahi kaise hai? They are not satisfied with your affidavit. Tell us why the records are not here. Why did you examine? Look here. Ask your registrar to be here on the next date. You would like to know. It's a serious matter. You are questioning the very existence of the institution. You don't maintain records. The teachers would not get an opportunity of participating in other competitive exams wherever they are required to furnish experience certificate. This is a callous approach. If that institution doesn't exist, rightly you have rejected, but you have chosen to make him co-examiner. The appellant, an assistant professor in Netaji Subhash Institute of Technology, Amhara, Beta, Patna, an institute which is affiliated to Aryabhat Knowledge University, Patna, required the teaching certificate experience to be countersigned by the registrar of the university, which was refused on the ground that there is no record available in the university of the existence of the college. Aggrieved by the aforesaid refusal of the registrar of the university in countersigning the experience certificate forwarded by the management of the college, the appellant approached this court via CWJC number 8884 of 2020, which has been disposed of by order dated 28/10/2021, accepting the statement of the university that no record of the college in question is available with the university, justifying the refusal of the registrar of the university to countersign the experience certificate. Mr. Kaushik, पूरा नाम क्या लिखते हैं आप?
Kumar Kaushik.
Mr. Kumar Kaushik, learned advocate for the appellant, has drawn the attention of this court to the advertisement issued by the college for selection of candidates on the post of assistant professor and the merit list, as well as the appointment letter of the petitioner as assistant professor in the stream of mathematics in the college. Mr. Kaushik has also drawn the attention of this court to a communication made by the university to the petitioner, making him a co-examiner of the university in the subject mathematics in the year 2016. On the basis of the aforenoted documents, Mr. Kaushik contended that the learned single judge was not justified in accepting the contention of the university, the Aryabhat University, that there is no record of the existence of the college in the university. The Aryabhatta, Mr. Can I name आपका?
Priyank Deepak.
Mr. Priyank Deepak, learned advocate for the Aryabhatta University, is directed to file an affidavit sworn by the registrar as to how, in the absence of records of the college in question, the petitioner, the appellant who claims to be an assistant professor in such college, has been nominated as a co-examiner in subject mathematics. Let such an affidavit be filed by the next date. Re-notify on next week, Monday.
My lord.
4th of July.
My lord, in one place, in place of merit list, it should be faculty list.
Merit list नहीं लिखना, faculty list. Merit list कहाँ है? For the faculty list. Yes.
For admission 1, CA20, Mr. Vijay Kumar.
इसको चलेंगे. After lunch, after the case in the chambers, will resume.
My lord, serial number 25, I may be permitted to withdraw.
Not, acha, you want to withdraw? Item
My
number
lord.
25. You are Mr. Gajendra Kumar Singh.
My lord.
Mr. Gajendra Kumar Singh, learned advocate for the petitioner, seeks permission to withdraw this application. Dismissed as withdrawn.
It may be heard tomorrow, my lord. Serial 20, it may be heard tomorrow.
हाँ तो आने दीजिए, अभी तो कॉल ही नहीं हुआ.
Serial 18 may be on Thursday, my lord.
Which number?
Serial 18, my lord. On Thursday, my lord.
18 में हमने पास ओवर कर दिया था. As prayed for on behalf of the appellant, re-notify Thursday का डेट दे दीजिए.
Obliged.
I was in serial number 18.
अब लंच के बाद बैठेंगे क्या? लंच के बाद. अब लंच के बाद बैठेंगे. वो मेरा 23 है.
मतलब अब लंच के बाद ही आए ना हम लोग?
हाँ हो वही.
एक कैसा? 2:30 बजे से.
चेंबर 2:30 बजे से है. और उसके बाद नहीं है. और सब चीज कौन चलाओ
और ये ठहर बैठे ना जरा ठंडा. आपको तो कोटा खत्म हो ही गया. अरे आपको तो कोटा खत्म हो ही गया. हड़बड़ाए हुए ज़्यादा. 4 को छापे में 4 मिनट में तो बता दीजिए.
ये 18 मिनट
ये बैठेंगे ना.
थर्सडे को रहेगा. थर्सडे को.
ये वाला
किसने हुआ है?
क्या हुआ?
यहाँ दे दीजिए हमरा नहीं दीजिए
नमस्कार सर, सवा दो में लिस्ट ही है कि चेंज हो रहा है? सवा दो में यही लिस्ट चलेगा कि? अच्छा, हियरिंग होने का उम्मीद है? हियरिंग पर जो केस, क्योंकि हियरिंग का पहला केस मेरा है।
सर फाइल नहीं लेता है यूपीएस सेक्शन, जैसे कि आज एडजॉर्न हो गया, आज रहना था और फाइल नहीं लिस्ट पर है तो हम लोग दिए तो नहीं दे रहा। हेलो
हाँ सर। हाँ ग्राउंड तो आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ है, वही ग्राउंड सेटअप है।
नहीं पढ़ते हैं। मेरा पहले भी है साइड में तुम क्या किया था ना फाइल दिया थे
देखिए पहले और तुम करिए बोलिए order is beyond revision and that is my basis. It has been written in the substantial portion of law and by submission.
अरे पहला फाइल मिलता था फिर दोबारा फाइल मिलती।
पहले जो बालाजी कुमार का पॉलिटेक्निक में होता था वहाँ से अंदर राजेंद्र राणा 15 नंबर रोड पॉलिटेक्निक मोड़ से बच्चे वाला रिक्शा मिल गया 15 नंबर रोड कितना पता है 6 बजे समझना कि मतलब वैसे एक बार आप 4 बजे के लोग बात कर लीजिए हमसे, अगर हम 4 बजे पूछ लिया था 5 साढ़े 5 में आ सकते हैं थोड़ा पहले से नहीं तो उसके बाद आई नहीं तो कल आई नहीं तो कल आई हाँ आज ही 8 बजे 8 बजे से 9:30 तक 9:30 हो जाता है आप आए हुए हैं ना हाँ तो मेरे जाना नहीं जाना है क्या जब कोई बात बोलिएगा तो दोनों का अपील खारिज कर देगा इतने भर बात है तो आप अपने सीधे आप इतना लंबा चौड़ा बात नहीं बोलिएगा आप सीधे बोलिएगा कि हम लोग प्रयास किया सेटलमेंट करने का सेटलमेंट के लिए तैयार करेंगे तो ऐसा जो आदेश पारित कर दिया जाए इसके लिए हमको जाने का जरूरत है जो ऑर्डर होगा उसमें हाँ सुबह बात करिए असल में हम फाइल तो हम बात सुबह भी किए तो फाइल छोड़ दिए उधर से फाइलें भी चली गई फिर ठीक हम तो बिना फाइल दिए तो जाके इतना ही यही बात होना है
ऑनरेबल का नंबर चाहिए तुमको, टेक्निकल का नंबर चाहिए। और ठीक है, हम मार्केट को देंगे, ठीक है।
हम लोग कैसे कर रहे हैं, लिस्ट नहीं होगा सर, ये सब सेक्शन क्यों नहीं बोलते, जो जगह तुम लिस्ट कर दोगे, हम कर दे संभाल के
पहले आप लोगों से पूछना पड़ेगा, कुछ बोलेंगे। मैं बात करूँगा उसके बाद, ठीक है। शायद 10 बजे हमारे घर कोई रेफरेंस नहीं आ रहा, शुरू आ रहा है तो डायरेक्ट बाहर से प्रॉब्लम क्या है, एयरपोर्ट छोटा है, 4 कैंडिडेट ऑलरेडी है, बैठने की दिक्कत होगा, परमिशन मिलेगा, खड़े करना पड़ेगा। ठीक है, मैं बात करूँगा उसके बाद, ठीक है।
बादल से फोन करा बोलिए बात बताइए 12 बजे कोर्ट में बैठा मैं उसको फोन क्या कर रहा था ठीक है सर हाँ नहीं तो हम लोग का है जाके एप्लीकेशन तो लेके गया था लेकिन उसको नहीं किया है कोई तो अब लेके जाएगा आप बताइए जैसा कि मैं हम काम करने के लिए पढ़ाई करेंगे बात तो नहीं ला सकती है
इसीलिए इसे बोला ये सब फाइल कराना है ये क्या रहा है नहीं लेंगे
लेके जाए तो फॉरवर्ड करने वाला
कल आएगा ऑर्डर होइले रहना चाहिए तो लिस्ट पर क्यों नहीं के जवाब देगा
हाई कोर्ट से कुछ नहीं मांगा इससे नहीं फॉरवर्ड करेगा तो नहीं मैं आप क्या बोले
होगा हम किस सेशन से लाएंगे
हां वो नहीं करेगा
ये ना हम लोग क्या सब फाइल लिस्ट पर रहने वाला
है पेंडिंग है ना
हैं ये सब पेंडिंग है ये सब फाइल लिस्ट पर रहने वाला है तो लिस्ट पर काहे नहीं है तो अब हम लोग क्या करें
हम बोलते आप रिसीव करो जब दोबारा चढ़ेगा तो देगा क्या बोलो ना
हाँ बोल दीजिए कि समझा फाइल भेजते हैं लिस्ट पर रहेगा चढ़ेगा तो लागे
हां चपल वाला का है हां वाला नंबर हाँ उसका वो नहीं लिखा हुआ ऐसा ही
अगर किसी के साथ चलना पड़ेगा
आप लोग का सीट है आप लोग जैसा तो अपना रुपये बैठे जैसा नीचे खड़ा करेगा
अपना घर में थोड़ा लेके जाना आप लोग अपना अपना घर से बोला लेके जाना इसको चढ़े जाते थे ना बोला बोला अच्छा कौन भी हमें कर रहे बाहर बाहर बोले सब चीज अपना मार्केट कीजिए हमसे कोई नहीं होता हाँ रंजन भाई ठीक है सुनिए हमारा एलपीए कुछ में पहले ऑर्डर हुआ था अगर पेंडिंग नहीं दिखा रहा है लिस्ट पर उसको फाइल को हम भेज देगा रिसीव कर लीजिए अगर लिस्ट बनेगा नंबर बंच में जा रहा बहुत सारा केस जा रहा है उसको आप रिसीव कर लीजिए जब लिस्ट में आएगा ना तो फिर आपके यहाँ से मंगा लेंगे हमारे यहाँ जो पहले के लिए है यहाँ फाइल आ चुका है मेरे पास वो भी लिस्ट पर नहीं है ठीक है लिस्ट पर नहीं यहाँ पर छोटा छोटा जमाव में दिक्कत थोड़ा फायदा नहीं तो अभी हम आपके यहाँ रिसीव करा देते हैं फिर जब लिस्ट पर आएगा तो आपके यहाँ सब नहीं आएंगे हाँ ठीक है फिर आप रंजन जी को बोलिए रंजन जी बात पूछा बोलिए जो बोले
ठीक है सब भिजवा देंगे सब लिस्ट बनेंगे
अरे होगा
ये फाइल रहना चाहिए लिस्ट पर नहीं है
लिस्ट पर चौपट का रख दिया लिस्ट सेक्शन और कसल किसको मालूम नहीं क्या हमारे यहाँ चलेगा
ये सब लिस्ट पर का केस है मैंने 25
आपका मतलब है इस बार
जो चढ़ेगा उसके फाइल आएगा बस खत्म जो लिस्ट बनाना चाहते नहीं तो ऑर्डर ये सब कहा जाए तो पहले तो नहीं करता हाँ यार
मतलब इसमें बुलाया उसका
अरे ब्लड चेक करा चलो
सब फाइल भेजा
जोर से करने वाला भिजवा दीजिए, फिर लिस्ट बनेगा फिर हाँ फिर लगे और नहीं होगा तो राजीव जी को एक उस बात ये थोड़े नहीं लेते हैं वो एक त्रिपाठी जी है वो क्या राजीव से बात कीजिए, आप राजीव से बात कीजिए, अभी लोग क्या बोले बात कीजिए, राजीव जी से बात कीजिए, ठीक है आपको सीधी बात सीधा राजीव से बात कीजिए, बात ना बात कीजिए रोहित वो जो यार है हां वो है नहीं
केस के लिए बना
Just
कौन कितना नंबर है आपका?
आपके के साथ में
22 पर 22 पर काउंटर का समय हुआ है, तो काउंटर जरूर कहाँ है 22 में 22 में काउंटर तो है। प्रपोज तो चल जाए फुल मैच है, भेजिए फुल मैच
फुल मैच में
हाँ
ये तो डिस्पोजल किए हैं बैच कैसे
कौन बैच कैसे
हाँ हाँ
अरे प्रपोजल प्रपोज कैंसिलेशन वाला होना चाहिए तो ये फुल बेंच पे भेजो
ना वो अच्छी कंपनी है
21202 नहीं भाई
528 16 लोग कैसे एक साथ डिस्पोजल किए ऑर्डर देते हैं 18/5 को 5 उसी हिसाब ना कर रहा फिर
कौन
प्रपोज कैंसिलेशन में सिटी वाला
नहीं जो उसने प्रपोज कैंसिलेशन नहीं था
प्रपोज
नहीं आप आज बात कीजिएगा देखिए क्या होता है वो प्रपोज उसमें बहुत कर रहे थे वो कह रहे थे कि नोटिस जो है अंडर सेंट्रल गवर्नमेंट क्या ये उसमें दिया गया, ये बिहार टारगेटेड में नोटिस नहीं दिया गया उस पर
नोटिस प्रपोज कैंसिलेशन का उसको डील
अच्छा देखिए डील उस पर नहीं गए हैं तो देखिए आप ऑर्डर देखें इसको।
हाँ
ठीक है तो डील नहीं किया प्रपोज कैंसिलेशन नहीं
डील किया
ठीक है ठीक है ठीक है ठीक है ठीक है आप कीजिएगा देखिए फुल मिल जाएगा आप इसको कीजिए फिर भेजा नहीं फुल मिल क्या दिक्कत एक सौ बहुत सारा करके फुल मिल बनेगा तो देखा जाएगा
मैं उसका साथ लिए हम तो देखें 16 को नहीं जिसको
हाँ अरे उसमें हमने मोस्ट ऑफ इट
उसमें फूड सिक्योरिटी एक्ट 2013 के अति किया था।
अब उड़ाए पेट्रोल नहीं है वो ऑर्डर वही नहीं एकदम बिल्कुल हम एकदम घर में
दिए
लिखे हैं लेकिन वो ऑन द ग्राउंड ऑफ दिस वो उसको रिमांड किए वो नहीं किए प्रपोज कैंसिलेशन को नहीं किए जबकि हम लोग कहे भी कैसे प्रपोज कैंसिलेशन का भी दे रहे नो आई एम नॉट ऑन दैट
उसमें
लिखे हैं
नॉट ए सिंगल सो फॉर हैज बीन इश्यूड
single
proposal of
no it has not been said देखिए ठीक है याद ही पड़ा मैं बस है नहीं तो
आप फुल जजमेंट
हाँ भाई
किए हैं
हाँ भाई संदीप कुमार
फुल जजमेंट कोर्ट किए हैं हालांकि सुप्रीम कोर्ट किए हैं।
अच्छा ठीक है कोई बात नहीं लेकिन वो मैटर अब याद पड़ गया संदीप वाला मैटर था कौन केस नंबर याद है नहीं पड़ रहा केस नंबर है लेकिन सर नेटवर्क फुल नहीं चल नहीं रहा नेट नहीं चल रहा चलिए ना
संदीप कुमार
चलिए ना
16 को केस
हाँ क्या है कुछ कर दिखा कैसा बोल सकते हैं भगवान
केस नंबर है 518/2005
इसमें हम ही हैं हम इसमें हम पर्टिकुलर के 2000 बहुत सारा लास्ट फूल जाइए तो ना करो अंदर में खुलता है गड़बड़ आएगा खुल आएगा He has further drawn attention of this to the provision contained in clause 27 of the Bihar targeted provision which mandates that no order of cancellation of the license shall be made until the license has been given sufficient opportunity to state his case against the proposal of the cancellation. To supplement his argument, Mr. Singh has drawn the उसका information लिखा है आई देखिए चेक किया है forces are taking into account the verdict of the apex court in Golkha Secretary has held that in any notice required of taking the action which is proposed to be taken is very important. The fundamental purpose behind serving the social notice is to make the noticee understand that precise case set up against him, which has to be. This has further elaborated upon the insurances. However, a caution also sounded that even if the proposed action is not especially mentioned in the so-called notice, but the same can clearly and safely be discerned from reading thereof. यही आपका है। तो इनका कहना है कि अगर उत्तर कार्रवाई है, that is equally good as proposal because there is no punishment in the previous control orders. Only punishment is for contents of the notice. It has alleged on behalf of the state that from the fair provision of the notice, it is appeared that on a decision Secretary of the Department of Food and Civil Supply and inquiry was constituted against the notice.
3 बजे कौन रहेगा? 3 बजे
not just in a project.
उसका प्रेसिडेंट
Mr. Singh, that was when we voted for Buxom as submitted in all the whole contention of the state are not worth accepting. If the notice itself for faulty, it matter assuming but no admitting that the charge has been responded to for the all practical purpose core issue, namely response of the notice to the proposal to board would not have been answered. With respect to the party, the needless case only after what is the replies and reporting them here and hearing a decision to be taken to the within the year of direction.
Petitioners have been according.
Ample of funny safely on the civil notice not disclosing the cause of action and under which act under which act वो centrally notice किया हमें we set aside the order of the constitution. ये नहीं है, proposal वाला नहीं है।
उसको भी
कहाँ की?
Disclosing the cause of action.
Disclosing the cause of action. That is not आपको तो एक आपने डिस्कस पड़ा हुआ वो नहीं है, ये नहीं है वो। अब आपको बहस कीजिएगा अब बहस कीजिएगा टेस्ट कर लीजिएगा बहस कीजिएगा देखिएगा फुल मैसेज हो जाएगा आप सब आपके ये रिजल्ट कर लीजिए ठीक है पहले आप टेस्ट कर लीजिएगा
इसको सुप्रीम कोर्ट सब सब प्रोपोजल
हाँ भाई
एक बार
एकदम बिल्कुल
एगो बात
हम भी एडमिट करते हैं उनका यूज होता है लेकिन सिमिलर मैटर जो
और किया तो हम भी
कहीं तो सोच गुड पास
वो तो हम भी जानते हैं लेकिन बैच केसेस में जो है ना ये यहाँ तक है कि डबल ट्रिपल सुपर आलोक है तो कहना तो कहा जो आलोक जी भी बोले नोटिस को कहाँ चला
नोटिस लिए नोटिस अंडर डिफरेंट प्रोविजन नोटिस कर दिया सेंट्रल क्या है उसमें क्या था
वो फूड सिक्योरिटी
फूड सिक्योरिटी एक्ट में किया था
2013
उसमें किया था उस पर रुका है उसमें क्या है कि आप पीजीएस टारगेटेड पीजीएस कंट्रोल ऑर्डर के में नहीं थी प्रोविजन में अब नोटिस देयरफॉर दिस ऑर्डर इज बैड इसलिए डिमांड किया क्या दीजिए इसमें जवाब देगा इसलिए
बोल
हाँ मैं बैठे तो अच्छा मैं बैठे तो अच्छा
मेरे वो ऑफिस में
क्या सब दो हो जाएंगे Asociação da equipe, como performance, né? Isso que ela fica aqui. Não vai ser, não vai ser. Falou ninguém.
काउंटर करने दे रहे हैं
उनको नहीं ऑर्डर हुआ था
पहला
आपको समझा देता है अचानक कि लिख के ऐसा किया कि हमको डिस्टर्ब कर देगा ये ना एक के साथ रहा है वो किसी
फास्ट टाइम चालू किया है
गलत ऑर्डर हो गया मैंने लिखा दिया एक के साथ देखिए ये आई एम टॉकिंग अबाउट ये 23/20 का नोटिस हुआ 11 वाला उसमें पहले नोटिस हुआ था उसके बाद ये दिखे नहीं है कि उधर से कमेटी में अगर उधर से फिक्स किए ये क्वान्टिटी जो फिक्स मैंने फिक्स कर दिया था एबिलिटी फिक्स कर दिया था हमें उसके बाद ये उसमें पेमेंट नहीं हुआ फिर अभी शुरू हुआ सबको नोटिस किया गया पहले भी आए थे डिमांड हुआ ये भी है क्या
मुझे को प्रोसीजर नहीं है डिवीजन डिवीजन है
ये जो है इसमें पहले भी आए थे इसके बाद डायरेक्टली बहुत ऐसा लगता है कि वीडियो लिखता है और द वीडियो और माननीय ये सब मामला अब एक और अगर उधर से क्योंकि यहाँ नहीं गए हैं लेकिन यहाँ PDC ही निकाला देखिए और पढ़ना पड़ता है उन्हें डील किया अगर किया गया ठीक है ना किया गया सवाल में से कोई कह रहा है कि हम उसको भी कर गए तो बिना मेरे सुना गया जब तक आवेदक के पास स्थित अवशेष तो उसके बाद उसे फेंक देने के प्रश्न है आवेदक सबूत नहीं कराया गया कब्जा की स्थिति और किस स्थान पे का गया उसका कुछ साक्ष्य दिया गया इस समय हम लोग 3 सितंबर में सूचना दी गई नहीं, चावल की दी गई। सेकंड राउंड ऑफ लिटिगेशन कॉपी का जो है यही हो गया था। अब जैसे मीटिंग में पेपर नहीं थी ये हम किए अगर होंगे तभी लाइव शिफ्ट हुआ है, दोनों बात है। अब मीटिंग में सिंगल में मीटिंग से भेजे लेकिन भेजे कम है तो लेकिन यहाँ भी सीधी से यहाँ पर कोई नोटिस नहीं आया था और उसकी पॉलिसी फॉलो करने नहीं आया नहीं होगा
after proper hearing. टाइम सवेरे है।
दिखाई पड़ता है कि कुछ खाया चावल इनका कहाँ गया ये सब बिल्डिंग में लगा ले बिल्डिंग में लगता ना हम लोग तो चलते फिरते वाला नहीं है इधर से सब नहीं है अगर पूछा रांची आए जरा नाम पे क्या ये कहते हैं कि हमारा सब समाज सेवा हम लोग विजय से पूछेंगे इसमें इतना अच्छा कि इसको हो ही नहीं सकता कहने के लिए कि बढ़ता है 2 मिनट में जिसको पैसा उतना मिलता है और सर्विस मैटर ले लीजिए सारा दी जाते रहते
संबंधर बाबू हमको बोल रहे तो उनका इधर तो डेली छाटी होता है आपके पास मुसीबत है दुनिया 10-20 लोग बहुत बात होता है सुन रहा होता है कितना काम कर लेते हैं
काम कर पैसा कैसे मैनेज करता है ये नहीं कह रहे
ना हम कहते थे सुनना ना कोई जैसा क्या किया इतना मेला लगा रहता था हम करते हो फाइल में कागज में काटो बांधो नमस्कार पैसा दे देना है रखो हम जाते हैं कोर्ट आएंगे तब देख लेंगे
जो देना है मिनिमम इतना मिनिमम उसके ऊपर जितना
ना हमारे यहाँ का
खाने का तो भाई वही वाला बात है दसवां दिखाई नहीं पड़ता
खराब हो चाहे हाथी हो क्या कहते हैं रिन्यूअल ऑफ लाइसेंस हो चाहे बच्चा हो निकलना ही कितना निकला है तो बताएंगे
पूजा तक अच्छा कैसे चला
हाँ उनका बूट पड़ता कि
अंग्रेजी कहाँ निकल जाते हैं उसमें बहुत लिखा में
उसमें कितना हो गया अब ना बॉक्स मशीन में गड़बड़ी ना
अच्छा अच्छी बताओ हमको समझ नहीं क्या क्या चीज
मशीन क्या है देखिए मशीन आप दीजिए इंटायर रिकॉर्ड आपका A to Z कंसर्न अथॉरिटी टॉप टू फूड कमिश्नर को गवर्नमेंट किया
नहीं लेकिन यही स्पेसिफिक लिखना पड़ा ना
एक बताते हैं आपको एक्चुअली ये लोग का सर्वर पूरे सप्लाई डिपार्टमेंट पूरा सर्वर के साथ अटैच ठीक है। अब आप यहाँ ऐसे दिए वहाँ जैसे यहाँ जितना माल उसका निकलेगा वहाँ लिखाएगा
लेकिन क्या है कि बहुत जो ट्वीट किया
उनका आगे ऑर्डर से निकलवा के जो है जो आएंगे तो बोलिए ऑर्डर से निकलवा के भेज देंगे
पर क्या आप तो जिला कहीं कुछ कर ले लोग जो करता है आप वन नेशन वन राशन कार्ड आप विद इन इंडिया किसी दुकान से आप ले सकते हैं। तब कहा आपको कोई गाली देगा चाहे कम
उसका कहना है, देखिए उसके
वाला केस में हो रहा
पब्लिसिटी वाला केस में क्या उसका स्पेसिफिक था कि वन ऑफ द फैमिली मेंबर और से वही रास्ते निकाला तो रिलेटिव होगा या फैमिली मेंबर और कुछ मिले कि भाई उसने निकाला पूरा रोई कार्ड
चैम्बर में केस चल रहा है।
सिंपल बात है, देखो निगरानी सब थी, हारा हुआ मुखिया जीता हुआ, हारा हुआ अरे सर कितना नाम की विपत्ति तो नाम की विपत्ति आप केवी जो है कितना को खुश करेगा ये कितना होगा तो बिना उपेंद्र है तो बिना दी के दूसरा
लगा दो बिजली पे लगा लिया
अभी दरभंगा वाला सुन रहे हैं वहाँ भी आएंगे फाइल किया था चीफ जस्टिस डीलर क्या करता है आप समझिए और परिणाम बात है सबसे बढ़िया रूल intention is आदेश किसी व्यक्ति के किसी चीज के जो इस आदेश के अनुसारण सद्भाव पूर्वक किए या किए जाने के लिए कोई बात अभियोजन या अन्य विधिक कार्य में की जाए। इंटेंशन जैसे कि प्रोटेक्शन ऑफ एक्शन
of action taken under the order no suit prosecution under the legal shall lie against any person for anything which is done intended to be done in good faith. अगर आप किया कि बहुत सोशल लेकिन दूसरे का बात नहीं
इसमें क्या वो तो केस में है टेंशन न
रीजन है कि भाई आप दुकान तो यहाँ पर दुकान रखे हैं उससे दूसरे जगह बजाय वो लेकिन इन्फॉर्मेशन अगर किसी कारण से अनाज सड़ जाएगा इन गुड फेथ वहाँ से
दूसरे जगह पूरे कोई अदर नहीं अच्छे का वही सुन रहे थे उसमें जानते हैं कंप्लेनेंट जो था यहाँ आने का यहाँ
चेंज किया है
सामुदायिक भवन में रख दिया
गवर्नमेंट का
बात है विरासत के नुकसान one day elimination one day closure
हम जाएंगे आप करिए
पहले तो प्रपोजल
ये जो है जो भी वो है ब्याज सर्विस कोई और था ब्याज जीरो का होगा ब्याज एक ये जीरो नहीं
बंटवारा हुआ सामान आया खाना अलग दुकान पर क्या भैया उसके बाद देश का माने ऑनलाइन फाइलिंग बना ऑनलाइन फाइलिंग तो ऐसे ही चल रहा ये जो आजकल है ना विश्व ये सब ऑफलाइन ऑनलाइन चलने के लिए चुप के पास होगा अगर फिर मैच कैसे रहता अब एक विकेट छोड़ के चले जाएंगे आज फिर
देखेंगे सर स्वयं में तो छोड़िए हम तो कह थे क्योंकि प्रॉफिट और 5-10 केस खेल लगा दिए हैं और उसके
को टॉप में पहले सुन लेते हैं इसलिए आधा घंटा में निकाल अभिनंदन हो 25 को इसी एक्स्ट्रा
इसमें भी टाइम पर मास्टर साहब, अरे इसमें उस दिन हम लोग कहे थे तो कहे टाइम फिक्स हो जाएगा। टाइम और फिक्स होता तो हम लोग या तो सेकंड हाफ में आते हैं तो फर्स्ट हाफ में आते हैं।
सेकंड हाफ में तो टाइम फिक्स है।
कहाँ टाइम का नो
एलपीए का उड़ गया। नहीं है सर, एलपीए का
हैं
2 एलपीए का कंफ्यूजन है।
हां
एलपीए का और ये आपका नन सर्विस मैटर और फिर अदर देन ट्रेड एंड कॉमर्स ऐसे इसकी
हां
सब केस ही बोलते हैं।
इससे केस कम है
इसकी जो है एलपीए और
इसका कम
और क्या बचे
ओ
में बहुत कम है।
फिर पे नया एलपीए नहीं
जो है नया एलपीए फर्क कम है।
नहीं कहाँ होता है
चलिए इसी एक्सरसाइज काम चल रहा है, पूरा दिन दिखता है।
हाँ अच्छा इसीलिए हम लोग परेशान इसलिए हो जाते हैं। तो आओ सब मेट्रोपोलियन तो है ना
नया रिलीज आप देखे होंगे, 8 नंबर 9 नंबर नोटिस देखे होंगे कि कोविड पीरियड में जो केस फाइल हुआ है उसकी सुनवाई होगी बुधवार, बृहस्पतिवार और शुक्रवार। और उसके पहले के जो केस लिखा जो 24 मार्च 2024 का नोटिफिकेशन आया है पेंडेमिक का, उससे पहले जो लास्ट डेट जो लास्ट कोर्ट था जो लिस्ट था उससे पहले का जितना भी केस है तो सोमवार मतलब आज आपको केस मिल रहा है, कल एक पास हुआ है, सब मंडे को जाएंगे। मंडे ट्यूसडे मंडे बाकी 22 तारीख पर 2022 का देखिएगा तमाशा बुध बृहस्पति शुक्र दूसरा कल 22 को दिखने लगा। जी सोमवार मंगलवार और कोरोना स्थिति सोमवार मंगलवार है वो सब जो है बुधवार शुक्रवार। लेकिन पंडित कौन दिखाती है, पंडित कौन दिन दिखाई सोमवार मंगलवार ये तो लिस्ट में साल बहुत समझ एक कौन देखेंगे, लेकिन कौन पंडित दिन देखा
कोई पंडित जी जो हेड ऑफ
इसको दे दीजिए
हेड नहीं सर, लेकिन ये अगर ऐसा होता कि अब 20 तारीख पर जो है, लेकिन सर 18 19
सब चलेगा वही नॉर्मल में। अरे सुनिए ऐसे समझिए दो मंगल लगता बुध में इस काम कर रहा है टाइगर वाला तो टाइगर पे रहेगा। हां वही
जीबी बेंचमार्क बुधवार को है तो उसमें तो इसलिए किए रहेगा खत्म हो जाएगा। अच्छा जो मैटर रहेगा तो नीचे डाउन लिस्ट होता है
तो ये नहीं बोलूंगा नारायण जयंती चलिए 18 19 क्या होगा 60 दिन के अंदर डिसाइड कर दो। ऐसा थोड़ी कि कॉस्ट लगा देंगे।
देखिए कंटेंट फाइल करके आप कोई हम लोग डिस्ट्रिक्ट मजिस्ट्रेट नहीं डेलीगेट किया कोई
ये बंद हो जाते डेलीगेट करेगा।
क्या लंबा चलेगा मेडिसन? कोर्ट मास्टर साहब मेडिसन लंबा चलेगा था? हाँ 3 बजे तक है ना, चलेगा। दोनों पार्टी का सही है, दोनों आया हुआ है। ऐश्वर्या को तो देखे थे, तेज प्रताप नहीं आया।
ये सब केस लास्ट मंडे और इसका है क्या? तो वैसे किसी है ना? ठीक है, सरकार ने चाहता उसमें ऑर्डर पास कर दी, जब तक आप असेंबली कमेटी से बात नहीं तब तक कोई कार्रवाई नहीं है। इसमें ये पैसे कुछ देता है कुछ देता है
कंटिन्यू बोल ना कंटिन्यू विड्रॉ किया कंटिन्यू बोल हाँ क्या बोला
हमको नहीं लगता है कि नीचे सूट बना पाए नीचे सूट बनाने का नहीं बट एक ही बाटी आया है दूसरा बाटी आया नहीं यहाँ पे बोल रहे हैं दूसरा नहीं आया ये भी बोल पा रहा हूँ मेडिएशन चल रहा है डिवोर्स से सूट है इसमें डिवोर्स कैसे हो सकता है डिवोर्स उसमें तो 1 साल के पहले ही फाइल कर दिया था मेंटेनेबल नहीं था उसी ग्राउंड पे आ गया है वहीं के है होना चाहिए क्या एक्सपीरियंस क्या था इट इज नॉट एज मैटर ऑफ राइट एक्ट आ गया ये अमेंडमेंट है एक्ट में तब उसके लिए होना चाहिए कि प्रीवियस लिटिगेशन होना चाहिए 1 साल से पुराना लिटिगेशन वो जो है सो 6 महीने का पीरियड 13B में जो होता था ना उसको तो बहुत सारे जजमेंट देते हैं कि 6 महीने के पहले भी हो सकता है प्रोवाइडेड बहुत सारे जजमेंट है दिल्ली हाई कोर्ट का जजमेंट होता है उसमें कहता है कि यदि आपका 6 महीना से पुराना कोई दूसरा डिस्प्यूट चल रहा हो एक ही दूसरा कि किसी को विदेश जाना हो और अगले में पासपोर्ट का रेडी हो वीज़ा रेडी हो इधर से तो उसको जाकर करेगा ना
चारों बचे
अभी क्या है तो कोविड टाइम टू टाइम आता रहेगा अभी क्या हटेगा इसे फरमाइश है कुछ अच्छा खराब भी नहीं लगता खराब भी नहीं लगता चप्पल जूता सब बचे ऊपर से कहाँ गिरेगा वहाँ नहीं गिरेगा डायरेक्ट
सिर्फ नहीं है लगेगा ना
इसमें फेंकने में बास्केटबॉल का प्रैक्टिस करना पड़ेगा वहाँ फंस जाएगा आगे फंस जाएगा ना इसमें हाँ आगे ग्लास में वैसे तो पीछे से उसको कर सकता है। यहाँ से वही है ना, ऐसे जाएगा, ऐसे घूमेगा तो उसको फंस जाएगा। आप फंस के घूमेगा तो डायरेक्शन फिर इधर ही हो जाएगा, डायरेक्शन उधर नहीं, इसमें गोल गोल घूमेगा। देखो इस्लामाबाद सरकार का पैसा है, अपने कुछ में लिप भी गिर जाएगा, वो है क्या लगा वो, लेकिन ठीक से लगाया, ठीक से जमाया है वो अच्छे से। क्या हुआ? स्टेट वो बन गया, पहला चीज था कोई नहीं बन गया, 8 साल तो फिर रहेगा। हेलो हेलो हेलो, हम तो हाई कोर्ट के अंदर हैं, आप आ गए क्या? कोई है वहाँ पे? सिमट खुला हुआ है? अच्छा ठीक है, बैठिए। जब तो एक मैटर है जस्टिस आशुतोष कुमार के यहाँ, उनके यहाँ करके आते हैं। 15-20 मिनट तो अभी हो गए। हाँ बोलिए क्या? नहीं नहीं बैठे वहीं पे, कहाँ जाइएगा? आपको अंदर आने को नहीं जाएगा अभी। एस्टेब्लिशमेंट आते रहते हैं क्यों? तो आप एक काम कीजिए, फिर बैरिस्टर एसोसिएशन में आ जाइए। बैरिस्टर एसोसिएशन गेट नंबर 2 से अंदर आते हैं कि गेट नंबर 3 से आपको? हाँ देखते हैं ना, हाँ हाँ हाँ, तो लेफ्ट टर्न करके वहीं पे उसी में बैरिस्टर एसोसिएशन ऊपर आ जाइए फिर। हाँ हाँ ठीक।
हेलो
हाँ अभी है टाइम नीचे
क्या आ रहे हैं
सिग्नल तो है कि आ रहा है देखना मेरे को
जो बचे हैं
जितने में आप स्टेट हैं काउंटर दे दीजिए काउंटर दीजिए नहीं एक्स्ट्रा क्या
ना उसमें नहीं सुमित
खत्म हो गया तो चेंज हो गया
सुनिए ना कल भी 500 पर हुआ है
सरकारी वकील लोग सोचते हैं बगल में एक केस में 25,000 फीस दे दो 15,000 जब तक 25,000 मिलेगा नहीं तब तक कैसे
देखेंगे यूट्यूब पर एक वीडियो
किनका क्या
कोई वकील साहब बात कर रहे थे वो समझे कि नहीं समझ गए समझे कि नहीं जैसे ही बोले साथ में बोले सॉरी ठीक है समझ गए अगर समझे कि
कहा कि कहा मुझे एक केस में गिरफ्तार किया उसके बाद सब केस में और ये सागर मान समझे कि
वकील साहब बोले समझे
ये बोले भी नहीं समझ गया
हाँ अभी बोला नहीं
मैंने आवाज कर दी
नहीं ऑन किया जाए ऑन कर दो सर
कौन है
क्या आवाज आ रहा होगा
सब जगह नहीं रहेगा हालांकि जाना नहीं चाहिए बाहर
सीनियर का पैसा लग गया बहुत तो बहुत पता लगेगा वो गलत कैप्टन यूट्यूब पे कैप्टन नहीं बताओ कैप्टन कोई और दे रहा
कहिएगा फाइल नहीं है
वो देना
हेलो
वही तुम बोल रहे अब क्या सारे के मांगे बोलते हैं लोग मना कर दीजिए
जाए क्या हम लोग घर जाए क्या आ रहा है
आ रहा है।
वहाँ खत्म हो गया है।
चैम्बर केस चला था।
चैम्बर खत्म नहीं हुआ।
हाँ खत्म हो गया, 330 में आ रहा है।
आज कितना तक कीजिएगा?
ठीक ठीक। ऑफिस सब
आप सब कुछ लिख दिया, आप सब कुछ लिख दिया, बोले पढ़ लीजिए।
वही लोग ऑफिस में हैं।
वो तो
बगल में आपका कपाम वही तो मैं पढ़े लिखे लिखता हूँ। पेशकार सर से मार मार नहीं पड़ेगा। लगवाइए विस्तार से।
है 2 दिन पहले बोले थे, वही हम देख लगा नहीं लगा।
आदत लगवा दी देखने का, वो
सो वही
जाना
बात,
पड़ता है।
परेशानी हम कल तक हो जाएगा बोलते हैं।
हम लोग ऐसा उम्र दराज आदमी के लिए नजदीक रखिएगा देखने की बढ़िया।
Yes. Call out.
Under heading for admission, CL 20, Mr. Vijay Kumar.
Yeah, please.
Yes.
Passing the order dated
Speak on the mic.
2019,
Mic.
my lord. That is
Sir, mic में mic में.
that is annexure 7, my lord, page 29. And earlier petitioner came this honorable court, that is annexure 5, page 25, my lord, on the direction of this
This
honorable
is
court.
Prakhand Vikas Padadikari. Who is he? What authority is he?
My lord,
He is not the licensing authority.
My lord, this is the second order of petition, my lord.
That's all right, but he has no authority to decide any petition, no?
Yes, my lord.
Was it directed by
compliance
anyone
of the
on
order of
bench?
this honorable court? It appears.
किस order के तहत आप वहाँ गए?
annexure 5, page 25, my lord.
No. This is not with respect to license. Notice for return of the rice. Are you a PAX?
No. I am PDS dealer, my lord.
You are a PDS dealer.
My lord.
Now, what notice did you get?
Notice is annexure 3, my lord. Annexure 3, page 22. Annexure 6 is my.
Just a minute. Mr. Rupen Pratap Singh,
My lord.
I don't know under what circumstance a bench of this court by order dated 11/7/2019
My lord.
directed him to go before the block development officer.
My lord.
But nonetheless, he went before the block development officer. But the court was conscious enough to say that if a certificate proceeding has been initiated, then he will have an opportunity to show cause.
Yes, my
Now,
lord.
has it been initiated?
No. Initiative or certificate proceeding? No.
Now, what is your ground, Mr. Rajkumar?
That is annexure 6, my lord, page 27.
Am I asking for the page number, Mr. Counsel, or I am asking you for the reasons in support or
reason that
claim?
No any direction give the petitioner for balance rice, my lord, and thereafter.
Now that you have the notice, return the rice 131 kgs of rice, and that also at the rate of 10 rupees
No, no,
per
131 nahi. I stated, I voluntarily मैंने stated 467 क्विंटल my lord.
अच्छा, आपकी राशि है 6,39,927.
हाँ हुजूर, ये आप कह रहे हैं कि 6,39,000 पहले
हुजूर,
दिए थे
पहले
दिए थे 1,79,000 का नोटिस. उसके बाद आया कि नहीं आपको इतना जमा करना है.
Because you are continuing with the litigation. You should have paid that amount and should have come out free of the responsibility. We are not interfering with the order.
तो जो उस समय का जो रेट था 6 रुपया कुछ पैसा था, अभी 18 रुपया कुछ पैसा करके डिमांड कर रहे हैं.
क्या करेंगे? You have only caused. You have yourself caused this.
अगर उस समय का जो रेट है हुजूर, वो हम जिस समय चावल दिया गया तो वो रेट पे हम रिटर्न करने को तैयार हैं.
11 में एडमिटेड फैक्ट है कि 11 में भी नोटिस किया गया था. 2000 उदय सिन्हा कमेटी हुआ था, बना था हुजूर.
देखिए, we are not inclined.
नहीं तो हुजूर, अगर वो चावल खराब हो गया, हम लोगों ने बार बार कहा है एनेक्सर 2 एनेक्सर 1 के द्वारा कि आप हमको डायरेक्शन दीजिए क्या करना है. किसी तरह का डायरेक्शन नहीं दिया गया, और न कहीं किसी को डिस्ट्रीब्यूट करने का आदेश दिया गया, तो हम लोग को उसको फेंकना पड़ा. 1 साल के बाद 2 साल के बाद तो खराब हो जाता है. गोडाउन तो कहीं हमको मिला नहीं था, हम लोग तो अपने घर में उसको रखे हुए थे. और जब हम लोग ने बार बार कहा कि भाई हमको आदेश दिया जाए क्या करना है, किसी तरह का आदेश नहीं हुआ. अब 2005-6 के बाद एक बार 2011 में कहा जाता है कि आप पैसा जमा कीजिए, जबकि उसके पहले हम लोगों ने इन्फॉर्म किया है. और उस समय का जो रेट था 6 रुपया कुछ पैसा, भी हो कहा जा रहा है कि 18 रुपया कुछ पैसा पर जमा किया जाए. तो अगर हम रिस्पॉन्सिबल है तो पदाधिकारी भी तो रिस्पॉन्सिबल है उसके लिए.
आपने जब डिस्ट्रॉय किया
माय लॉर्ड,
उसका कोई डॉक्यूमेंटेशन किया आपने?
अब जो उसका क्या डॉक्यूमेंटेशन होगा, तो इसे ही सर के गांव में उसका दुर्गंध आ रहा था तो गांव से बाहर फेंकना पड़ा उसको.
न्यायपालिका आपको नहीं बताएगी कि उसका डॉक्यूमेंटेशन कैसे होता है?
अब उतना अगर नॉलेज पीडीएस डीलर को रहता हो, जो कहा गया और उसको लोग फेंके, तो ये हुजूर कर दिया जाए कि जो उस समय का रेट था जो हमको दिया गया था, उस रेट पे हम जमा कर दें.
Where did you make that prayer before the BDO?
My lord. Annexure 6, my lord. Annexure 6, as paid 27, my lord.
निवेदन पूर्वक करने के सार्वजनिक वितरण प्रणाली अंतर्गत स्वर्ण का एक विक्रेता है जिसका अनुज्ञप्ति संख्या स्वर्ण श्रीमान को ज्ञात हो कि श्रीमान के कार्यालय से 280 पर ज्ञापांक संख्या स्वर्ण द्वारा डिमांड नोटिस निर्गत किया गया था. स्वर्ण जमा करने का निर्देश दिया गया था. उपरोक्त राशि वर्ष 2003 से 2006 के बीच अधोशास्त्री द्वारा उठाव किए गए खाद्यान्न से संबंधित है. यह खाद्यान्न संपूर्ण ग्रामीण रोजगार योजना धारा का था, जिसके लिए सक्षम पदाधिकारी द्वारा लाभुकों को कूपन दिया जाता था एवं ऐसे कूपन को विक्रेता के समक्ष प्रस्तुत करने पर विक्रेता द्वारा अन्न बांटा जाता था. श्रीमान को ज्ञात हो कि उपरोक्त योजना के रूप में अधोशास्त्री के पास कुल 467.
Are you still the licensee under the PDS scheme?
My
Are
lord?
you still a licensee?
Yes, yes, my lord.
I think your license also was required to be cancelled.
ये तो बिहार में तो सारे लोगों का कैंसिल हो जाएगा, जो सारे लोगों के साथ ही घटना हुई है.
But we are not interfering with the order, and we will also suggest this. If you argue like that. सारे लोगों का केस तो यहाँ नहीं देख रहा हूँ ना.
नहीं, वो तो बात सही है.
लिमिट्स में आर्ग्यूमेंट करें तो बेहतर है. सारे लोगों का हो जाएगा तो so be it. What difference does it make? सारे लोगों का हो जाएगा तो is that a justification for interfering with the order?
No, madam.
Then on what legal ground are you resting your claim? सारे लोगों का हो जाएगा. आर्ग्यूमेंट हाई कोर्ट में अपील आर्ग्यू कर रहे हैं, उस हिसाब से बहस करिए. क्या डॉक्यूमेंटेशन कराएगा? You don't know what is the way in which documentation is done. जो बहस करना है वो बहस नहीं कर रहे हैं.
नहीं, knowledge
Now
क्या?
annexure, here the court,
My lord.
annexure 6 कब किया, कब इशू, कब लिखा आपने? कोई डेट नहीं दिया हुआ है इसका.
ये दे हुजूर की 11 एनेक्सर 5 के बाद हुजूर दिया है मैंने. और ये ऑर्डर पास हुआ हुजूर 5/9/2019 को एनेक्सर 7, और अर्लियर ऑर्डर है हुजूर 11/7/2019 का, तो उसी के बीच का होगा हुजूर. डेट छूट गया है.
Now where is the calculation? Now this quantity of rice
I
has not been
accepted,
changed.
my lord. I accepted 467 quintal, my lord.
467
Quintal.
quintals of rice. What was
I,
the earlier?
I honestly accepted, my lord.
What was the earlier?
Earlier 139, my lord.
No. 130. 467 quintals of rice was left behind.
This is the admitted factor.
Huh?
Admitted factor.
Admitted.
My lord.
And when initially you were asked to pay, what was the cost? At what rate was it quantified?
Earlier cost.
At what rate was it quantified that time, and what is the rate today?
उस टाइम हुजूर 6 रुपया 65 पैसा.
Where is that document? जैसे हमने एक नोटिस में देखा ना कि 10 रुपए का कोर्ट ने कहा था, वैसे आपको जब नोटिस दिया गया था उस समय कितने रुपए का कहा था?
इसमें तो जो रेट नहीं दिया हुआ है 131.
सारी जनरलाइजेशन वाली बहस करेंगे कि सबका कैंसिल हो जाएगा.
नहीं सॉरी मैम, 131 क्विंटल का था.
वो तो बहस ही नहीं है ना.
179.
467 quintals of rice is to be returned by you.
Yes.
Now
yes.
you want its quantification at the rate when it was first found that it was in excess of what you distributed.
Yes.
What is the rate? What was the rate then, and what is the rate which has been charged from you today?
अभी हुजूर 18 रुपया कुछ.
Show us from the order. We can give you some latitude in the matter, provided you argue like an advocate.
इसको हुजूर पास ओवर कर दीजिए. हम रेट मंगवा लेते हैं हुजूर.
मंगवा लेते नहीं है तो आप फिर बहस क्या कर रहे हैं? How have you preferred this writ petition? If you are asking the court to make some concession, to direct for some concession to be made to you with respect to quantification, you should have said that. देखिए साहब, कोर्ट को अगर आप इरिटेट कर देंगे जनरलाइज्ड बहस से, तो फिर जो ग्राउंड मिलना भी है वो नहीं मिलेगा.
सॉरी.
बहस वैसा करिए जो कोर्ट को ग्राह्य हो, तो कोर्ट खुद पॉइंट खोज के आपको देगा.
ये जो एनेक्सर 3 पहले जो
आप ऐसा करिए वकील साहब, आपको हमने रेज्ड वॉइस में बोला, एक कम से कम आप वो करिए कि एक उस वक्त जो नोटिस हुआ था, even though you have not received that notice, but that must be on record, the quantification at that time, what was the rate, and today when the amount of rupees 6,39,000 has been settled on you, what is the rate at which the rice has been quantified? We can direct for something. वो लगाइए. कहाँ से लगाएंगे? कैसे लाएंगे उसे?
निकल जाएगा हुजूर.
कैसे?
ब्लॉक से निकल जाएगा. जो उस समय हमको राइस मिला था, जो उसमें जिस रेट में मिला था, वो रेट का हुजूर चार्ट लगा देंगे. और अभी जो हमको डिमांड किया गया है,
why this enhanced rate? You can on that rate, if you charge interest,
yes,
that interest also would be chargeable from the date when it would be presumed that he had the notice that he had to return. Now even if you add that interest on the amount on the earlier quantification, perhaps it would be lesser than 6,39,000.
Probably, but the liability was fixed by
and how have you quantified it?
The liability was fixed by the Uday Sinha committee, my lord.
Uday Sinha committee has fixed the liability that he is required to return. Quantification, yes. Justice Uday Sinha has not done.
My lord, it is.
Quantification वो नहीं किए हैं. अगर किए हैं तो बताइए, then we will not interfere.
I will.
उस कमेटी के द्वारा तो जो दोनों को रेस्पॉन्सिबिलिटी फिक्स किया गया था।
जनरल डायरेक्शन वाज इश्यूड टू द
आपने जब
डिस्ट्रिक्ट
रेट फाइल किया तो
मजिस्ट्रेट।
ये नहीं सोचा कि ये बहस करेंगे कि वो इस रेट को लौटाना तो आपको है।
जी जी।
You can't run away from that responsibility.
Yes, yes, yes.
So as an advocate, did you not conceive of the situation that the court would be asking you for the comparative rates for quantification?
ये जो उस समय 6 रुपया कुछ पैसा का रेट था,
ये कहाँ प्ली लिया है आप बिफोर द वीडियो? आर्टिकल 226 में मैं क्या करूं? एक्सीड करूं? आई गो बियॉन्ड द बॉक्स एंड डिसाइड एवरीथिंग?
नहीं, या तो जो
आपने ये प्रे किया होता, उस अथॉरिटी ने कंसीडर नहीं किया होता तो मैं उसे फिर उसके पास भेजता।
ये हुजूर कर दिया जाए कि जो उस समय का रेट था उस पर हम
ये कैसे कर देंगे? आपने ये प्ली लिया, ये कंसिडरेशन वीडियो के पास था।
हम लोग तो हुजूर इसलिए चल रहे थे, मैंने वहाँ गए, कहा गया था कि चूंकि वो डिस्ट्रॉय कर दिया गया था इसलिए हम लोग लौटाने की स्थिति में नहीं।
We are directing him to file a fresh application, taking this plea that the quantification is more than what was in his expectation, and for no apparent good reason, the index of quantification has unnecessarily been enhanced. He is ready to make good the payment, to restitute the government, provided reasonable quantification is made. He will go before the BDO again, he will decide.
No, my lord, I think he may be directed to go before the collector.
Why?
Because of the fact, my lord,
therefore I asked the question.
Quantification was probably done by the collector, my lord.
Quantification was done by the collector.
Probably. Because all the district masters were directed to quantify.
But this is an order of 5/9/2019. How do we know?
A general direction was issued by which district magistrate were directed to mark these PDS dealers from whom this rice was to
That's
be
right.
recovered.
So across the board, this is the price which has been charged.
Ji, Your Lordship.
Across the board. And they have deposited that amount.
No, Your Lordship.
None of them?
None of them. They have approached this honorable court, Your Lordship.
And what has happened in those cognate
Nothing,
rates?
Your Lordship. Till date, nothing. No positive.
DB1 has directed कि उधर सिन्हा कमेटी ने जो लाइबिलिटी फिक्स कर दिया वो देना है।
नहीं तो लाइबिलिटी उदय सिन्हा कमेटी ने जो फिक्स किया है वो तो रिटर्न की दायित्व बताया है। क्वांटिफिकेशन तो नहीं बताया।
Quantification was not done.
Yes, sir. Therefore, my lord, he may approach to the district magistrate, my lord.
For that quantification, Your Lordship, district magistrate will be the appropriate authority.
You file your response to the petition. We'll consider. Now we are not going to make him shuttle from BDO to collector to commissioner. Now we'll say if there is no good reason, we'll say that the quantification appears to be bad. We might take a lenient view in the matter. We might. We don't know. Let us see your response first. Let counter affidavit in the matter. बहस को साइंटिफिकली लीगली प्रोसीड करिए। वो जो बेल वाली बहस करेंगे ना कि वो सब हो जाएगा, वो जेल चला जाएगा, वो कहेंगे तो फिर मैं कुछ नहीं करूंगा। Let counter affidavit in the matter be filed positively by the next date. Re-notify on 4 weeks.
26th of July. Cell 21. Mr. Dinesh Prasad Verma.
My lords, in this matter, I have a preliminary objection in this case. I am appearing on behalf of Respondent 6. Lordship, the preliminary objection is that, Lordship, the petitioner, without exhausting the alternative remedy of appeal and revision, he has directly come before this honorable court. And Lordship, Order 32, Sub-Rule 3 and 6 clearly says that there is provision of appeal and revision against the order of the SDM. And
in view of Whirlpool Limited, we reject your preliminary objection.
Then it's fine, Lordship.
Yes.
My lords, very simple question arises. The petitioner was appointed as a PDS dealer, and respondent number 6, my friend's client, made an application before the authorities that my mark sheet which I have deposited for appointment as a PDS dealer is not genuine. Then an inquiry was constituted by the district.
Tell us one thing, whether the respondent number 6, Chitranjan Kumar, was one of the aspirants.
He was aspirant or not, I'm not aware.
Yes, Lordship.
Yes. Therefore, the justification of Mr.
Yes, but I don't have that.
Otherwise, we would have non-suited him now.
Annexure 7 is the notice, my lords, which is the basis for passing the page 24.
Annexure 7.
Yes, I think, my lord, the ground number 3 is the ground on which the matter has proceeded.
तो ये तो बहुत का अंतर है।
बहुत आसान है, कोई
नहीं, बहुत का अंतर है, आसान नहीं
है। क्या कि
बीए 646 आपको है, आपने 500
बीए मार्कशीट फाइल हुआ और बीए ऑनर्स का दोनों हमने लगाया हुजूर, ओरिजिनल है। जवाब एनेक्स्चर 8 में देखा जाए हुजूर।
ये नोटिस हुआ आपको?
जी, पेज नेक्स्ट पेज पे जवाब हम लोगों ने दिया और कहा कि अगर कोई कंफ्यूजन है तो आप यूनिवर्सिटी से पूछ लीजिए, ये मेरा सबमिशन है। नेक्स्ट पेज पे भी उन्होंने लिखा है कि अगर हमारा फोर्जरी है तो आप
जस्ट मिनट। ये कैसे ये कहते हैं कि 517 था उस समय?
वो हुजूर तुरंत एक सेकंड में, उसके लिए अगर हम लोग हुजूर सीधे चले आए एनेक्स्चर नंबर पेज 33 एंड 34।
यस,
पेज 33 जो है ये हमारा ऑनर्स का मार्कशीट है। नीचे में देखा जाए हुजूर मार्क्स इन ऑनर्स 64.6 और 517 भी उसी में लिखा हुआ है हुजूर। और नेक्स्ट पेज पे हमने 2 मार्कशीट लगाया जिसमें कि 646 है।
ये कौन सा है? तिलकम
पास कोर्स का है। तो हुआ क्या होगा कि एप्लीकेशन के साथ एक लगा और हम जब इंक्वायरी में गए तो दूसरा फाइल किया है। ये एक सेकंड में वेरीफाई कर लेते कि सही है कि नहीं।
नहीं, उसके आप जब बीए ऑनर्स कोर्स करते हैं तो पास कोर्स का मार्क्स पे आपकी परसेंटेज नहीं डिटरमिन होती है।
तो दोनों मार्कशीट
दैट इज ओनली क्वालिफाइंग मिस्टर अग्रवाल।
इनका एलिगेशन ये कि हमने एक 517 के साथ अप्लाई किया और जब इंक्वायरी हुई तो 646 का मार्क्स दिया। दोनों मार्कशीट लगा है, दोनों यूनिवर्सिटी से वेरीफाई किया जा सकता है।
कहाँ गलती है? लेकिन आपको जब मार्क्स के बेसिस पर आपकी कैंडिडेचर होनी थी।
मार्क्स के बेसिस पर नहीं है, क्वालिफिकेशन पे है। मिनिमम मैट्रिकुलेशन
होना
चाहिए।
दोनों का क्वालिफिकेशन एक है तो मार्क्स जिसका ज्यादा है एज
नहीं, तब हुजूर उसमें ऐसा है पहले कि पहले कंप्यूटर नॉलेज है, फिर एजुकेशन है, फिर एज है। इसलिए वो इशू नहीं चलेगा हुजूर हमारे ख्याल से। इनका सिंपल इशू ये है कि हमने एप्लीकेशन के साथ दिया जो 517 बोलता है और बाद में हमने 646 दिया। हमने कहा कि आप यूनिवर्सिटी से वेरीफाई कर लीजिए।
How many persons were there? All right. So what has the cancellation? Let us
yes,
see the order.
Now cancellation order is annexure 9, page 29, my lords.
Yes.
मिडिल में उसी इश्यू को डील कर रहे हैं ये हुजूर, ये इनका मेन इशू है।
टीआर क्या होता है?
टीआर क्या होता है?
टैबलेशन रजिस्टर। टैबलेशन रजिस्टर कॉलेज में बनता है। कॉलेज यूनिवर्सिटी में।
हाँ, मार्कशीट रजिस्टर रहता है। ठीक है, रखते हैं। लास्ट में लगा
जस्ट कितने पेपर्स का पास कोर्स है आपका?
पास कोर्स ही है। ये लग रहा है 2 2 4
सर्टिफिकेट क्या इशू किया है?
10। मुझे बहुत सिंपल था, ये यूनिवर्सिटी से मंगा लेते कि दोनों जेन्युइन है।
नहीं नहीं नहीं, कोई सिंपल नहीं है। आप हम जेन्युइन कहाँ कोई नोबडी इज डिस्प्यूट।
यस, डिस्प्यूट भी नहीं है वो।
आप ये बताएं कि व्हाट इज द परसेंटेज गिवन टू यू इन द सर्टिफिकेट, फॉरगेट अबाउट मार्कशीट।
ये हुजूर अगर पेज 33 पर हम देखते हैं तो 507 भी लिखा हुआ है उसमें, 517 मार्क्स इन ऑनर्स 64.6 भी लिखा है। दोनों मार्क्स वहां पर भी लिखा है,
मार्क्स इन ऑनर्स 64.6 है
और 517 भी लिखा है। और नेक्स्ट वाले सर्टिफिकेट में 646।
तो कितने पास कोर्स हैं आपके?
इसमें लगता है 10 सब्जेक्ट्स हैं अभी। 190 जोड़ के एक का है, 199 और एक 195 का है। हम ग्रेजुएट हैं, डिस्प्यूट नहीं है। इनका डिस्प्यूट है कि 2 सर्टिफिकेट दिया। हो सकता है हमने ये दिया, इन्होंने 517 पढ़ा, हम इसमें भी डिस्प्यूट नहीं कर सकते। और मेनली यही ग्राउंड है इनका कैंसिल करने का।
ये उत्तीर्णता प्रमाण पत्र फर्जी पाया गया, ये कैसे लिखता है?
अच्छा, दोनों वाले फर्जी हैं।
फर्जी कैसे? Where is the report that
I
it
would
is
be
fabricated?
drawing your lordship's kind attention to page number 33.
Yes.
हुजूर इसमें एग्जामिनेशन का ईयर देखा जाए इनका। हुजूर ये सब्जेक्ट के जस्ट ऊपर में है। 2089 में ही पास कर गया।
मंगाएगा वहाँ से।
कहाँ पर है?
जस्ट सब्जेक्ट के ऊपर, जो सब्जेक्ट का कॉलम, द कॉलम व्हिच इज देयर योर लॉर्डशिप जस्ट अबव दैट।
Exam 2089 held in month of September 2089.
Your lordship, that is there, and one more thing.
2089 क्या हुआ?
जी।
नेम ऑफ द एग्जामिनेशन भी ऊपर दिया हुआ है। अब वो तो यूनिवर्सिटी से मंगा।
Moreover, your lordship,
Arts honors part 3 examination 1989.
Moreover, your lordships may kindly come to page number 29, the impugn order. That will clarify everything. It is an quite exhaustive order, your lordship. Shri middle, your lordships, after that column, श्री विजेंद्र मंडल द्वारा इंटर का अंक प्रमाण पत्र संलग्न नहीं किया गया, जबकि साक्ष्य स्वरूप चितरंजन कुमार द्वारा समर्पित टीआर में इनका इंटर का रिजल्ट पेंडिंग दिखाया गया है एवं स्नातक को
पेंडिंग रहेगा तो फिर ग्रेजुएशन में जाएंगे नहीं।
जी, दैट इज व्हाई इट वाज डिक्लेयर्ड एज अ फोर्स्ड डॉक्यूमेंट, योर लॉर्डशिप्स।
फोर्स तो पता कहाँ किया ये?
जी, सब्सिक्वेंटली जो ये विजेंद्र मंडल एक जगह लिख रहे हैं, उसके बाद जो डॉक्यूमेंट प्रोड्यूस कर रहे हैं, एक जगह विजेंद्र मंडल है, दूसरी जगह विजेंद्र कुमार मंडल है। That was the doubt which was created in the mind of the authorities, your lordship.
What I am submitting, lordship.
Just a minute, we'll ask you.
Yes.
ये जो 64.6% है, ये भी विजेंद्र कुमार मंडल है, दोनों विजेंद्र कुमार मंडल है।
जी हुजूर।
एंड इनकी सर्टिफिकेट भी विजेंद्र कुमार मंडल की है।
जी,
और लाइसेंस भी इनको विजेंद्र कुमार मंडल के नाम से मिला है। ये नीचे विजेंद्र मंडल, ये इसने कुमार छोड़ दिया है, ये अपने तरफ से प्रोजेक्ट नहीं किया।
इम्प्यून ऑर्डर हुजूर एक पैराग्राफ और है उसी में, subsequent paragraph.
फर्जी करने के पहले what necessary inquiry was made?
That is why I was making a submission, your lordship. There are disputed questions of fact involved in the present case, your
No,
lordship.
there is no dispute here.
And hence, your lordships, my respect.
We find that the licensing authority has of his own held it to be farji without inquiry. Yes, mister.
Lordship, in this matter, since Lordship has not taken my preliminary objection in this matter, so therefore, Lordship, I will annex the TR. So some short time may be granted. I will file my.
No, we are not.
Lordship, there are three types of documents, Lordship. First, they have what they have applied for, and next at that time it was a different document, Lordship. During inquiry, he submitted different document, and after during inquiry, I submitted his TR. That is a completely different document, Lordship.
Have you obtained any report from the university?
Lordship, I got TR from the university, Lordship, certified copy. I am having in my file, Lordship, but since I have not filed any counter affidavit, so TR is with me, and matter is different in the TR.
Now, in the
it is a certified copy.
Let me see.
क्या गड़बड़ी है सर?
No, we are only seeing it from the point of view of dubbing a certificate to be forced without inquiry. That's what is catching my attention.
Lordship, there are three types of certificates they are issuing, and Lordship, instead of 1989, September 1890, it has been written 2089 at two places. So that creates a doubt.
That's all right. Have you followed what the court is saying? These are the issues on which you are doubting it. Now the authority concerned ought not to have given your doubts a positive statement without inquiring into the matter. Now because you say that it is forced, should the authority write that it is a forced document?
Lordship.
Was it not incumbent upon him to inquire from the university?
Lordship.
Is he not a statutory authority dealing with all this?
Lordship, in this matter, inquiry has been conducted by different officer, that is annexer, that is annexer 6.
Yes.
Annexer 6 at page 22. And Lordship, upon this inquiry report, Lordship, the MP order has been passed.
इसमें कहीं से information
No, not at all, Lordship.
Then we set aside this order, send it back to him again to inquire properly, and then take a call.
From the registry, they will inquire.
They will set aside this order that it is based on no report. It is the presumption of the authority, and that presumption is based on the statement made by the complainant. Now, therefore, we are not restoring the license to him. The license remains cancelled.
Lordship.
But a fresh order is required to be passed after being satisfied that the document furnished by him was forged.
Document at the time of application, Lordship, not later on.
Whatever.
Yes.
Now, either of them has to be a forged document or a wrong document.
Lordship.
Otherwise, your contention is absolutely unjustified.
Lordship, he is entitled on the basis of the application which he has submitted at the time of application, Lordship. So, Lordship, the first certificate which he has annexed along with the application, that has to be verified, not subsequent one, Lordship.
No, it's all right. All the documents, which is correct. If the second time, if the document which was supplied for the second time is correct, then automatically he loses.
Yes, Lordship.
Because that's another document which he has filed.
Lordship, what I am submitting, Lordship, simply.
You are submitting what you are submitting. I am understanding.
Yes, Lordship. Yes. He does not have any subsequent claim.
We as justice dispensing system, we take very strong exception to saying that somebody is a fraud, somebody is bad, somebody is forged documents. Unless you have proof, you can't make that statement.
Lordship.
That's the thing which I generally very stoutly defend, the right of a person not to be defamed.
Lordship is correct. Lordship.
Suppose your adversary makes a statement that Mr. Aditya Prakash Sahai has made a wrong statement.
Lordship.
And if it is found that your statement is not wrong, I will dismiss his petition straight away.
Lordship.
Because it is one of the worst of the offences to defame any person.
Lordship.
Now this authority has come to the conclusion that the document is forged only on the basis of his personal information which has been derived from your statement. That is not the way in which a statutory authority has to behave.
Lordship.
That is the issue. Don't think that we are giving premium on wrong certificate.
Lordship.
Now we are not restoring his license,
Lordship.
not by any chance.
Lordship.
The authority has to pass a fresh order.
Fresh order.
And what the appellate authority would do? The collector would only toe the line of the licensing authority. Therefore, we are sending it back with necessary instructions.
My lords, I don't have any objection if the matter is remitted
No,
back.
we are not taking your consent, Mr.
No,
Agarwal.
what I submit is, they should furnish the copy of the documents on which they want to rely. That's only, whatever application I have filed.
They will make an inquiry with respect to documents which you have supplied.
Yes, with a notice to me, my lords.
Why notice?
From the authorities.
No, what will you do in Tilkamaji University? You will make them make them follow.
I will just want to know what documents they are referring.
That's right.
That's the only.
No, we will specify that he shall have it verified from the university, the genuineness of these documents,
Which
and
I have
shall
improved.
decide afresh. Finished.
Lordship.
Not on other issues. Like here.
Yes.
And decision may be made on the basis of first document, Lordship. ठीक है, तीनों का मंगवा ले यूनिवर्सिटी से.
वो नहीं कहें. If none of the documents are bad, then any document he may have furnished.
Yes.
If ultimately it is found that he has secured 64.6% marks, and none of these documents, none of these mark sheets are fabricated or forged, he remains the license.
Lordship.
That's right?
Lordship. Right.
Huh? Look here. Heard Mr. N.K. Agarwal, learned senior advocate for the petitioner. Mr. Upendra Pratap, you are for the state. Mr. Alok Ranjan, Mr. Alok Ranjan for the state, and Mr. Aditya Prakash Sahai for respondent number 6. Respondent number 6. On the complaint made by respondent number 6 about the petitioner having obtained PDS license on forged and fabricated academic qualification certificate, an inquiry was conducted in which it was found that 2 different mark sheets were given by the petitioner for obtaining the license. First up, as such, it was presumed by the licensing authority that the license has been obtained on a spurious document, leading him, a spurious document, first up. Consequently, the license of the petitioner was cancelled. First up, Mr. Agarwal, learned senior advocate for the petitioner, submits that there could be no gainsaying that 2 different mark sheets were offered by the petitioner, one at the time of filing of, one at the time of making application for grant of license, and the other at the time of consideration of his candidature. And both the mark sheets are genuine documents. First up, he further submits that 1 mark sheet is the total of the marks obtained by him in pass course subjects, whereas the other is the mark sheet of the subjects in honors. First up, he further submits that without getting the matter verified from the university, it was absolutely unjustified for the licensing authority to have declared the documents furnished by the petitioner to be forged and fabricated. There is substance in the contention of the learned counsel for the petitioner. Learned counsel for the petitioner. First up, the licensing authority ought to have taken care to find out from the university concerned about the genuineness of the documents furnished by the petitioner at any stage before declaring it to be forged and fabricated document. First up, it is nobody's authority to defame any person on a half-baked inquiry. First up, on this score alone, we are not in a position to sustain the order passed by the licensing authority, and we set it aside. First up, the matter is remitted to the licensing authority to pass a fresh order in accordance with law after verifying the genuineness of the mark sheets offered by the petitioner at 2 different stages, and affording a reasonable opportunity to the petitioner to explain his cause. First up, in case it is found that the order passed, that any one of the mark sheets furnished by the petitioner was not genuine or not issued from the university, the license of the necessary order shall be passed. Necessary order shall be passed by the licensing authority. First up, the matter thus is being relegated to the licensing authority to make a proper inquiry before passing any final order in the matter. We make it clear that we are not restoring the license of the petitioner in the interactor. The writ petition, Mr. Sahai, learned advocate for the petitioner, learned advocate for the respondent number 6, makes a preliminary objection about the maintainability of this case on the ground that the petitioner has not exhausted his legal remedy, not exhausted the alternative remedy of an appeal which is provided under clause 32 of the Bihar Targeted Control
Sub Rule 3.
32 Sub Rule 3.
In Bihar Targeted Public Distribution System Control Order 2016.
All right, he knows that. He knows that. Please take your seat. In response to the aforesaid statement, in response to the aforesaid objection, Mr. Agarwal, learned senior advocate, has submitted that in the event of the order being totally dehorse the requirement, totally dehorse the necessary inquiry, totally dehorse the in response to the aforesaid preliminary objection, Mr. Agarwal, learned senior advocate for the petitioner, has submitted that the order impugned in the present petition is absolutely non-est, as the mark sheets of the petitioner has been declared to be forged and fabricated without proper inquiry. अब उसके बाद ऐसे चलिए.
Some time may be fixed, Manor, for.
The licensing authority shall conclude the proceeding and pass a reasoned order within a period of 60 days from the date.
60 days. Inquiry has to be conducted from the university.
That's
right.
right.
So some more time.
So some communication has to be made. Why do you worry?
चिट्ठी लिखेगा फिर वहाँ से आएगा उसको more time लगेगा.
Within a period of 60 days. Don't worry. One communication from this side and the response communication from the other side.
होता ही नहीं होता.
At least
it is not practical.
All right. All right. You want him away from the system for further 30 days. That's right.
I am concerned the fact that in hurry he may not pass any order in absence of any report from the university. That is my concern.
The exercise shall be completed within a period of 90 days from to be counted from the date of production of a copy of this order.
Chalo.